Good morning, everybody, and our good friends from the Judiciary. It's a nice, beautiful Friday out there. It's supposed to be 70 degrees today, so we want to get done through this really quickly so we can go sit out in the sunshine at lunchtime. So, Chief Justice, welcome. Mr. Co-Chair, any comments?
No, it's good to see some of our friends from the judicial branch. You know, you look back here and a lot of them we have personal connections with, and that's one of the things that we love about Wyoming. You know, some of our daughters were in school together. Some of us served on law reviews together. Some of you, you know, threw my cases out of court. It's just wonderful to see. It's just wonderful to see y'all.
Okay, with that, Don, do we do a roll call or anything? Roll call.
Good morning, Mr. Chairman. Representative Kinner.
Here.
Representative Larson.
Here.
Representative Schwartz.
Here.
Representative Simpson.
Here.
Representative Stith.
Here.
Representative Walters.
Here.
Representative Guru or Senator Guru.
Here.
Senator Hicks.
Excused.
Senator Kinski.
Here.
Senator Steinmetz. Co-Chairman Perkins.
Here.
Chairman Nicholas.
Here.
Mr. Chairman, you have a quorum.
Okay. Please go ahead.
Mr. Chairman, and this is really for the folks that maybe be watching on YouTube and whatnot. Yesterday, we kind of had some technical problems. And the concern was that maybe you wouldn't be able to view everything. We would just remind them that these committee hearings are also recorded, and they can go on the website if need be at the end. And as much as we like technology, sometimes it drops just like everything else. And so we just would remind you that the recordings will be available as well. Thank you, Mr. Chairman.
Thank
Mr.
you,
Chairman,
Mr. Chair. All right, with that.
Mr. Chairman, before we get
Senator
started.
Steinmetz.
Yes, thank you, Mr. Chairman. I just wanted to talk a little bit about the Colorado River Compact that we talked about yesterday and just correct the record. The compact will not be renegotiated. It's just the rules concerning the compact. That's kind of a big issue. So if I wanted the record to reflect that, and we had an email from our good Attorney General reflecting that as well this morning. So I thought that was an important thing to bring out today. Thank you.
Thank you. Thank you for that clarification. Okay, Chief Justice, please proceed.
Thank you, Mr. Chairman, members of the committee. My name is Kate Fox. I've been chief of the Wyoming Supreme Court since July 1. I want to thank you, first of all, for your important work for the state of Wyoming. And thank you for your time and attention to this presentation on behalf of the judicial branch. Mr. Chairman, we will make this fast because we don't have a lot of exciting new things to request, and you can go outside when we're done. I'd like to first make some introductions. Members of the Supreme Court are here. First of all, Justice Mike Davis. I'd like to recognize him. He'll be retiring in January. He has given amazing service to the judicial branch as a district court judge, a Supreme Court justice, and just before me as Chief Justice of the Wyoming Supreme Court, a great jurist and leader. We're going to miss him very much. So that's the guy in the mask pretending, hiding and being modest, but I did want to recognize him. Luckily, we just found out we'll have a new justice who's Judge John Fenn from Sheridan, will be joining the Supreme Court in January. We'll be very fortunate to have him, and he will also be an amazing asset to the judicial branch and the people of Wyoming. Our other justices here are Justice Keith Couts, Justice Lynn Boomgarden, Justice Carrie Jo Gray. We have a bunch of judges here, and I hope I named them all, but you'll be seeing them during the course of the morning. As you know, Judge Lavery is the president of the District Court Judicial Conference. He's the judge in Sweetwater County. Judge Blumel is here. He's also a third district court judge. He travels between Kemmerer and Evanston. Judge Wilking is here from Casper. She's a Seventh Circuit Court judge. Why are you smiling, Senator Perkins? Who else? Am I missing DJs?
Brian.
I'm thinking DJs first, though. Okay, and we have Judge Brian Christensen, who's the president of the Circuit Court Conference. He's in Casper also. We will be going through the budget in a minute. Elisa Butler, our court administrator, will be doing the heavy lifting and turning the pages. Also, Claire Smith, our chief fiscal officer, is here. She's the one who did the heavy lifting and putting this budget together. But before I forgot to introduce Angie Dortch. Where are you? Hi. Angie is director of Equal Justice Wyoming. She's here in case you have any questions when we get to that program. I also see Diane Sanchez back there. She's the district court clerk in Laramie County and is here to keep an eye on us, I think. We're going to organize things a bit differently this morning. So in the hopes of respecting your time and getting you the information you need in an efficient manner. In a few minutes, I'll turn this over to our court administrator who will walk through the budget with you. We'd like to, Mr. Chairman, we would like to take this opportunity to talk to you about our Arpa requests, even though they're not part of the budget. If the committee pleases, we might start with that and then get to the budget.
Let's do the budget first and we'll do that last.
Okay, we'll do it that way. We plan to conclude at 10 so that the district court judges can present their budgets after the break. I'd like to just start with a very brief refresher on the judicial branch structure. There's a chart in the materials we provided, page 6. Most of you are familiar with this, I know, but not all of you are. And I'd like to just talk briefly about how the court is set up with the Supreme Court, 5 justices, constitutionally created body, which has the oversight over most of the judicial branch. Then the district courts, there are 24 district court judges. That is also constitutionally created court. And Chancery Court, I'd like to mention briefly because that was open for business December 1st on Wednesday. You'll recall, especially Senator Perkins, but all the rest of you, this was created in 2019 by the legislature, and our staff and branch, with the help of the district court judges, has done, I think, a remarkable job of getting everything together, promulgating rules, figuring out e-filing, establishing a structure. We have the district court judges volunteering to serve as Chancery Court judges during an interim period before a full-time Chancery Court judge is fully justified by the volume of cases. Representative Walters asked me a minute ago how many filings we'd had. As far as I know, we don't have any yet, but it's only been 2 days. So we think it will come. And we're pretty excited also about the fact that this is our first trial court that is fully electronic filing. And so it's a great opportunity for us to pilot e-filing, which will be coming in the district courts very soon. Then, as you see on your chart, the circuit courts, also 24 judges throughout the state. Those are statutorily created, and they are under the control of the Supreme Court. So the clerks of circuit court actually are employees of the judicial branch, whereas the clerks of district court are not. District court clerks are elected county officials. So with that, we'll have a tiny civics lesson because I know you know this. The judicial branch exists to provide the just, speedy, and inexpensive resolution of the citizens' legal disputes. Our role in the constitutional system of checks and balances, I think, Senator Perkins, you told me this last time we met, is to say what the law is, but whenever possible to defer to the policy decisions of the legislature. We do not choose the type or the volume of cases that we decide. We simply do our best to address the matters that are filed in our courts by private litigants and by the state. I heard the governor on Wednesday talk about the challenges to the fabric of our society. And I think it's true that the judicial branch is a mainstay that keeps the fabric of our society strong. So I appreciate your support. Our combined budget request for this biennium is about $92 million, which constitutes roughly 3% of the general fund budget. Elisa will be addressing the details. I wanted to draw your attention to a few budget requests that I think are critical for your attention and for the judicial branch and the state of Wyoming. First of all, and this is not in the budget, the Joint Judiciary Committee passed a bill for 3 new district court judges. And I want to talk to this committee briefly about the importance of getting those 3 new judges. They will be in the 3rd, which is Uinta, Lincoln, and Sweetwater County, in the 7th, which is Natrona County, Casper, and in the 6th, Campbell, Crook, and Weston counties. In each of those districts, there are 3 district court judges doing the work of 4 judges. And our district court judges will tell you more about it because they're the ones in the trenches. But I want to emphasize on behalf of the judicial branch how very important it is for us to get those 3 new judges so that they can keep up on the workload for the people of Wyoming and maintain the efficient and timely resolution of legal matters. Also, so that we can have workloads for our judges that allow them to have a sustainable life, and so that we can continue to attract good applicants for those positions. So I urge this committee, when this comes before you, to support the addition of the 3 judges. We have a few budget exception requests that I want to briefly mention. One is for a workload time study for the circuit courts. That's just $250,000. We need that for 2 reasons. Everybody wants data, including us and including legislators, understandably so. We have had workload studies for our courts for a number of years. The standard is to do a new baseline time study every 3 years. We haven't done one for the circuit courts for almost 10 years. And we have just converted our system in the circuit courts to an upgraded chamber management system that requires different time studies. So that's one relatively small exception request that I hope you provide us. We also are requesting an upgraded appellate case management system. That's e-filing in the Supreme Court, which we have had for a number of years, but that system is at the end of life. You actually approved the funding for that upgraded system in the last budget, and then in the cuts last year, they went away, and we're working on duct tape now, and we really need that $1.7 million for the new C-track. We have an exception request for Chancery Court, which is $814,000, furniture and equipment to finish off the Casper courtroom in the new Casper office building, and funding for some chamber staff. It's a very fluid situation with Chancery Court right now because we are unable to predict the volume of filings. And so we're working now. We have an excellent chief legal counsel and all around person who is running Chancery Court. His name is Ben Birmingham. He's managing everything for the time being, as well as supporting the 3 district court judges who will be doing Chancery Court work. If we get a greater volume of cases, which we hope to, we'll need more support staff. We may need to hire a full-time Chancery Court judge. So part of this money is for personnel should we need them. And then finally, I want to address an issue that's also not in our budget that the governor spoke to you about on Wednesday, and that's pay for our employees. We have in the judicial branch only about 330 employees. And if you take out the judges whose salaries are statutorily set, we're talking, about 270 employees. Not that many people who keep the whole judicial branch running. And they also are in the same boat as the other state employees that the governor spoke to you about. They are paid far less than market. And as a result, we have the same problem that the other state employees have, and that is a lot of turnover, inability to keep people, for example, clerks in our circuit courts can get paid much better even with comparable county jobs. So we have openings that stay open longer. We have people who leave after a few years, just when they're getting really productive. We have, for example, in our court administrative staff, we have an opening for a SQL data person that's been posted for 3 weeks. We've had no applications. And so that's the kind of thing that we're dealing with in the judicial branch. And it impacts our ability to continue to serve the people of Wyoming. I would also say it's not right. We should be paying our good, hardworking people a fair wage. And so we would ask that, and I appreciate that Governor Gordon has included the judicial branch in his fiscal note in terms of getting pay raises for our people. And I fully support that initiative and ask that you provide a pay raise to judicial branch employees. With that, if you have no questions for me, I will turn this over to Elisa Butler.
Thank you. Please proceed. Good morning.
There. Good morning, Mr. Chair, Mr. Co-Chair, members of the committee. My name is Elisa Butler, and I am the State Court Administrator at the Wyoming Supreme Court. I have the great privilege of flipping through the book with you today and presenting the Supreme Court budget. The Wyoming Judicial Branch employs some of the best and brightest that this state has to offer. These are people who get up every day, put their heads down, and do the important work of the judiciary. It's a great job that is both challenging and rewarding. While our judiciary is really great at a lot of things, one thing that it is not great at is saying uncle when the work becomes too much and the resources and more resources are needed. The 23-24 Supreme Court budget reflects this concept. It is a fiscally responsible approach to ensuring the continued operation of the courts. There is nothing new or out of the ordinary in the exception requests I will present to you today. Generally, they maintain the status quo. However, as we move through the budget today, we'll be pointing out a few areas where additional future resources will be needed. In other words, we will be coming to you soon and saying uncle. The budget, I'd like to go through a couple of things on the budget presentation itself. As I said, I will present the Supreme Court budget, which is made up of 8 divisions. We'll go through each one of those divisions. The district court budget will be presented by Judge Lavery, who is the president of the District Court Conference. As you know, and as the chief already mentioned, the district courts are free of administrative and fiscal control of the Supreme Court. However, Claire Smith, our chief fiscal officer, does help them create their budget. Each district court is a separate budget with its own appropriation. We'll end with doing some ARPA requests if that's if that's okay with you, Mr. Chair. We'd like to give the district courts enough time to speak to you today and end up with ARPA. That's acceptable. Okay. So a few notes about the budget itself. The language that we use within the Supreme Court budget, as I mentioned, is made up of 8 divisions, which includes both the circuit courts and the Chancery Court. We will go through all of those divisions, as I said. The judicial branch budget refers to the branch as a whole, including the district courts. So basically everything that you have in that budget book in front of you. There are also a few differences between the executive branch and the Supreme Court budget. The Chief Justice approves and recommends the Supreme Court budget, not the governor. Our budget book does not go to the governor for approval at all. Another example of that difference is if you turn in your budget books to SC8. What you'll see there is a table of the expenses. Generally in the executive branch budget, you would see one more column titled Governor's Exception Changes. That is not in our budget book. It's one of the advantages of being a small branch. Our exception requests are vetted through the chief before they even make it to the budget book. So there are no changes from the Chief Justice once it is in that book. With that, Mr. Chair, if there are no other questions, I will just dive in. All right. So what you'll, turning to SC1, what you'll find on SC1 through SC3 is the Chief Justice Fox's recommendation of a $63.5 million budget for the 23-24 biennium for the Supreme Court.
Mr. Chairman, I'm sorry, was it SC or SE?
SC.
C, okay.
It includes a list of each exception request for the Supreme Court. We'll go through each one of these in depth as we move through the budget book. Moving to SC5, listed in the first 8 rows under this description are the 8 Supreme Court divisions. All of those divisions, except the circuit courts and the Chancery Court, serve the entire branch, not just the Supreme Court. So something to keep in mind as we move through. On SC6, you will find an analysis of the allocation of funding for the Supreme Court. The majority of the budget goes to pay employees. You will see 75% of the Supreme Court budget pays salary and benefits for our employees. The judicial branch, as the chief mentioned, has 329 employees. 228 of these are reflected in this allocation. The remaining are district court employees. Nearly 50% of the Supreme Court budget is allocated to the circuit courts. There are 29 circuit court courthouses throughout the state with 154 employees keeping those courts running. Technology is always an area of interest for this body, I know. And so what you'll find is 18% of our Supreme Court budget is dedicated to technology. This funds everything from some personnel to hardware and software to run the entire judicial branch, including systems used by the clerks of district court who are county employees. On SC7, you'll find a summary of exception requests and priorities. Again, what you should see here is that there's nothing new, nothing really out of the ordinary. These are the required costs for the courts to operate effectively. At the bottom of that page, you'll find exception requests for the Chancery Court. The Chancery Court, as the chief mentioned, is unique. We are still building this court and this division. It's not fully staffed yet, and it is in a temporary space housed at the Supreme Court. We'll go more through that budget exception request as we get to that unit. So, Mr. Chair, I want to be mindful of the committee's time while still addressing questions and concerns with you here today. I would also like to provide, as I said, sufficient time to Judge you guys tell us to do. Oh.
Do it all you want. It doesn't.
No, we did.
On this pause, tell me what page you're on now.
We're still on 7, yep. Is it working now? Okay. All right. So, Mr. Chair, I want to be mindful of the committee's time while still addressing any questions or concerns, but I also want to make sure Judge Lavery has plenty of time to talk to you here today. We know that most of you are very familiar with the Supreme Court budget. You've heard our spiel a number of times in the past. So with the chair's permission, we'll run through the units that are business as usual and focus on those units with exception requests.
Okay.
Happy to hear it. All right, so the first division that we'll run through today is the administration division, that is SC8 through SC19. There are 4 units in this division. It is made up of administration, pro se packets, the Children's Justice Project, and Equal Justice Wyoming. The last 3 units in this division are business as usual with no exception requests. They also all operate using special revenue funds or federal funds and have no general fund dollars allocated to them. The administration unit begins on SC 9 through SC 10. The Wyoming Constitution provides the Supreme Court with superintending control over all inferior courts. Essentially, the court is responsible for not only producing opinions that provide precedent for the state, but it also is charged with ensuring the smooth operation of the courts throughout the state by providing administrative support. This unit funds those Supreme Court duties. It funds the Supreme Court chambers and personnel and operating costs, which is charged with interpreting state law and setting precedent. It funds the Supreme Court Clerk's Office, personnel and operating costs, which keeps the record of the Supreme Court and manages admitting and maintaining the status of Wyoming State Bar members. And it funds administration, personnel, and operating costs. As I mentioned earlier, I'm going to make a few statements as we go through to tell you where future funding or resources are likely needed, and administration is one of those areas. Surrounding states, administrative staffs, South Dakota, for instance, has 50 members of its administrative staff. That includes its IT staff. Our staff is made up of just over 30 employees at the Supreme Court administration. So it's quite a difference in terms of the staffing levels for court administration. Court administration does a whole lot, from coordinating robing ceremonies to creating a $92 million branch budget. Admin does it all. Thanks in no small part to my predecessor, Lily Sharp, the administrative staff is phenomenal, but we need more of them. We're not asking for more as part of this budget, but we will likely come to you in the future and request additional positions to help us support the courts throughout the state.
You can have her back.
We'd take her. The exception requests in the administration unit are just under $476,000. Again, there's nothing new here. We're just maintaining the status quo. The first exception request begins on SC 9 and extends into SC 10. This is the weighted workload time study that was mentioned by the Chief Justice. This is our first priority. It's a one-time cost, but as the chief mentioned, it really is ongoing because we should be doing these statistical analyses, a new workload time study every 3 years. That's the current national standard. So everyone knows what the workload study looks like, or should be fairly familiar with it, but there's a lot of steps that make up that workload study. We have provided you with a handout on page 7 of the materials. And this basically walks through what happens when we create a new workload time study. The first step is to hire a statistician who works with stakeholders, so judges and clerks throughout the state, to understand how their time is spent and to create categories to allocate time to each of those categories. Then the judges and the clerks go through the painful process of doing the time study, which means they keep track of every minute of their workday for 3 months. The statistician then does some statistical modeling. So they look at the time spent by all of the clerks and all of the judges, and they come up with what we call a case weight. So that is the number of minutes that is spent on each type of case. For instance, I believe in the circuit courts right now, one of the case weights for, I want to say protection order cases is 62 minutes. So basically it takes that court 62 minutes to dispose of that case throughout the entire life of that case. The next step is to take the number of case filings each year in each of those case categories and multiply it by that case weight. And that will give us the workload of the circuit courts of both the judges and the clerks throughout the state. We can use that to determine how many full-time employees we need and if we need another judge.
Chairman.
Go ahead, please.
Thank you, Mr. Chairman. On the workload study process, what is there, with respect to doing that, do you have any idea or can you help us understand, have there been, what would be the difference between the workload studies that have been done recently? Although in the circuit courts, not for the last 10 years, according to your information earlier, what is there changes, is there updates? What kind of, what would be the difference? Anyway, just, that's the question. How is this going to be different than others?
Mr. Chair, Mr. Co-Chair. So the last time study was created in 2012. Every year, what we do is we take that time study, we plug in the number of filings, and we multiply that case weight. So the things that have changed since 2012, at least in the circuit courts, which is where we're asking for that new workload study, that new statistical modeling, are the biggest one is the new case management system. So we have fully rolled out full court enterprise in the circuit courts throughout the state. That has substantially changed the processes of the circuit court clerks. One of the things that they do now that they never did before is they actually scan documents. So documents will be available electronically on our public access system at the courthouse terminals once we get that up and running. And that's a lift for them. That's something that they never did before. There are other small changes in that case management system that change the processes of those clerks, but I would say the biggest is the scanning. They are now required to keep basically 2 records, the paper record and the electronic record, all up to date and matching. I also think there have been, and I would ask probably Judge Christensen can speak to this more accurately than I, but I believe there have been a few changes to the law which creates more time to dispose of some of the cases that come through the circuit courts. So those are examples of some of the things that would change those case weights now.
And thank you for that. And Mr. Chairman, if I can follow up, one of the things that I think has changed significantly since 2012 are the use of the pro se filing system. I think there's been a substantial increase in that as we've made these forms available through equal justice and other things. So you have, and I know there's a list that you have of the different cases of when we get to the pro se form section. But I just, as a curiosity, I think what that does as those cases continue to increase is I think it changes the time study. And so I'm interested in your thoughts on that. And the way that I think that happens is visiting with some of our local judges is when we don't have pro se litigants, we don't have attorneys involved, it takes significant more judicial time than when you have attorneys involved, which maybe seem a little bit counterintuitive, except for the fact that attorneys actually do a lot of the work that help move the judge's case along, where when pro se litigants happen, the judges kind of have to wear 2 hats, although they have to kind of like straddling between the dock and the boat without the dock tethered. So sometimes, just be interested in your thoughts or your discussions about how that's affecting and how that gets wound into the case study, because it changes the amount of time that they have to spend on these cases.
Mr. Chair, Mr. Co-Chair, that is absolutely true. I would say at the circuit court level, there's always been a substantial number of pro se filers. We deem them the people's court for a reason, and that's because they deal with litigants themselves and less so with attorneys, although they do see attorneys. And I would, again, I would defer to Judge Christensen on whether there's been an uptick at the circuit court level in pro se filers. I think it's absolutely true at the district court level. And what I would say is, the chief mentioned the workload study and the fact that we are short judges, and that is part of that bill that was sponsored out of joint judiciary. That workload study was developed in 2012. So when you think of in terms of pro se filers, it's likely that they're spending much more time on those cases now than they were in 2012, because I think there has been an uptick at the district court level for pro se filers, people not represented. So, the workload study for the district courts shows we're short basically 3 judges, but it could potentially be more based on the fact that time study is so old and things have changed substantially since 2012.
Go ahead.
And the one thing that might be helpful to do that is if you could provide us information on pro se filings, probably both at the circuit court if that's trackable. So whatever data you can have on that, I think it'd be helpful for us to know.
Mr. Chair, Mr. Co-Chair, we can get that.
Thank you.
Mr. Larson.
Thank you. So I'm having a little trouble trying to connect the dots here. We've got an old time a workload study in 2012 that we're saying is outdated. We need to update it to determine what we need for resources, human resources. But yet we're recommending 3 new judges without this new one being done. And so if I'm gathering correctly, we're saying, well, we're making that decision based on this outdated time weight study. Have I got that right?
Mr. Chair, Representative Larson, the workloads, the 3 new judges are based on the 2012 time study that was done. And I think what you will hear from the district court judges is it is outdated, and a lot of those case categories, the case weight, the number of minutes that it takes to get through those cases has gone up substantially. The number of filings, I think, has stayed pretty consistent, but the number of minutes it takes them to work through those cases has increased.
So then are you saying that if they're suggesting that it would further substantiate that need? Or are you saying we should wait and get this done before we do the judges? Would that make more sense?
Mr. Chair, Representative Larson, I would say it would further substantiate the fact that 3 new judges are needed. And so the workload study that we're requesting, the exception request we're requesting today is for the circuit courts. We are not requesting a workload study for the district courts at this time because we are in the process of rolling out a new case management system and shortly an e-filing system, which will also change the processes.
Thank you. I had the disconnect between the circuit and the district. Thank you.
Okay, go ahead.
Okay. All right, moving on to the next exception request, which begins on SC10. It is a position transfer. This is a net to 0 exception request. We are requesting that 1 position from the law library unit be moved to the administration unit. This is just to align the tasks of that position, who does more work for the administrative staff than it does for the law library currently. There is still support provided to the law library through that position, but they have shifted duties to administration. So we would ask for that net to 0 request in the amount of $206,000. The next exception request on SC10 is for office equipment. We have 2 aging copiers that need to be replaced. One was purchased in 2008 and one was purchased in 2015. We don't generally follow the 5-year cycle of the executive branch to replace copiers and run them until we just can't anymore. So we can't anymore. We need 2 new ones. The total exception request for that is just over $19,000. So the total unit budget request with exception requests for the admin unit is just under $10.6 million. Moving on to the next unit is this is the Pro Se packet unit. It begins on SC12 and extends through SC14. This is a small special revenue fund with no general fund dollars. Today, we're requesting the standard budget of spending authority in the amount of $50,000. And Mr. Chair, unless there are any questions, I'll just go ahead and move on.
Mr. Chairman.
Go ahead.
Thank you. Good question back on the office priority 5 on the copy machines. Are these copy machines obviously used to copy, but are they also scanners that do they also use them to scan and then that loads documents into the case management system as well?
Mr. Chair, Mr. Co-Chair, yes, they are scanners. They do it all.
All right, thank you.
Okay, moving on to the next unit is the Children's Justice Project, which begins on SC15 and extends through SC16. Again, this is one with no general funds. This is federally funded program. We are asking for spending authority in the standard budget amount of $649,000, $649,282. The next unit within this division is Equal Justice Wyoming. That begins on SC 17 and extends through SC 18. Again, this is funded through special revenue and one small federal VISTA grant. There is no general fund dollars allocated to this unit. We're requesting spending authority for the standard budget amount of just over $4 million.
Right, Mr. Chairman,
Please.
going back a little bit, I'm trailing just a little bit behind, but you're going fine. Don't slow down on my account. But back to the Children's Justice Project a little bit. And when we talk about the Children's Justice Project and we talk about changes of law, have there been changes of law in the last number of years regarding children's justice and oversight and how we deal with juveniles that have also increased the workload for judges?
Mr. Chairman, Senator Perkins, yes, there have been a number of changes in abuse and neglect requirements. For example, there are already a number of federal requirements that have been incorporated into Wyoming statute for a very fast timeline. For shelter care hearings have to be within 72 hours. Then there have to be a series of additional hearings at regular intervals, 30 days typically. Just last year, the legislature enacted a new requirement for an additional hearing that has to do with when a child is recommended to go to a, what are they called? Thank you. QRTP, Qualified Residential Treatment Program. So yes, that's one of the areas where the workload of the district court judges, and in this case, acting as juvenile court judges, is increased by the enactment of additional requirements, in this case imposed by the feds and then enacted by this legislature.
Thank you.
Next division within the Supreme Court budget is the Judicial Nominating Commission. That begins on SC 20 and extends through SC 22. Wyoming follows the merit selection process for judicial vacancies, which is something we're very proud of. The Judicial Nominating Commission is an integral part of this process. Interested candidates generally submit applications. The Judicial Nominating Commission reviews those applications and interviews the candidates in the location where they are going to be seated. So there are travel and meeting costs associated with the Judicial Nominating Commission. The commission itself is made up of volunteers. So there are 3 attorneys that are appointed by the Wyoming State Bar, 3 non-attorneys who are appointed by the governor, and then the Chief Justice serves as a non-voting chair of that commission. Once the Judicial Nominating Commission does interviews in the location where the judges or justice is to be seated, 3 names are selected. Those 3 names go to the governor, and the governor does interviews and then appoints from those 3 names. The exception request that we're making today is for additional funding for travel for the Judicial Nominating Commission. We have seen an uptick in judicial vacancies recently, and we don't expect that to recede over the coming years. For example, Chief Justice Fox has had the pleasure of doing 6 interviews, I believe, with the Judicial Nominating Commission since she has become chief, so in the last 6 months. And so it has been a substantial turnover currently, and we think that will continue over the coming years. So this is an ongoing request. Historically, this budget has been inadequate to cover costs. So we are requesting a total exception request of $17,000, which would make the total unit budget request with the exception request just under $35,000.
Mr. Chairman,
Go ahead.
thank you. So you've had an uptick in the number of cases. Do you have an understanding of the underlying cause of that? Go ahead.
Mr. Chairman, Representative Schwartz, Justice Burke suggested that it has happened just since I've been chief, and there's some correlation. I think there may be a couple other reasons. One is just age. As you know, we have mandatory retirement for district and Supreme Court judges at age 70, which seems younger and younger to me these days. Circuit court judges do not have mandatory retirement, but they age too and get tired. So that's a lot of the turnover that we've seen. And for a couple of judges, I would say burnout and is the reason for the vacancy. I expect that this pace of openings will continue.
Go ahead.
Mr. Chairman.
Please.
Just following up on that, I'm just wondering if you have, if we look at our, both our district court level and our circuit court levels, how many judges are, are approaching that age of 70 in the next few years, if you know?
Mr. Chairman, Mr. Co-Chair, I think Claire and I were looking at that list in anticipation for preparing for this next biennium. And what do we come up with? Maybe a prediction of about 8, 9. And then, of course, what happens too is, for example, Judge Fenn hasn't left the judiciary, but now there's another vacancy. And as judges possibly move up, for example, circuit court judges who may apply for district court positions, that's also one of the reasons for the opening. So then it's great to have Judge Fenn on the Supreme Court, but now we have to go find a judge in Sheridan.
Mr. Chairman.
Go ahead.
Thank you, Mr. Chairman. Just for my own education, the commission pays for the commission members' travel. Does it pay for the judges that are being interviewed to travel to those locations for their interview?
Mr. Chair, Representative Walters, it does not. The applicants pay for their own travel to the location.
Okay. go ahead.
Okay. The next division within the Supreme Court budget is the Chancery Court Division. That begins on SC 23 and extends through SC 27. As the Chief Justice mentioned, this was a legislative creation in 2019. The purpose was to create a court to provide rapid resolution of complex business cases. Chancery Court, we are happy to say, was open for business as of Wednesday. The chief mentioned it's a very big lift to stand up a new court jurisdiction in 2 years. That is thanks in no small part to the Chief Justice herself, who chaired a committee to get that court stood up. The chief also mentioned that it is an electronic court, meaning that we have mandatory e-filing in the Chancery Court. It's housed in the Supreme Court, but it will transition to the State Building in Casper. Just a little history on the budget. Originally, the legislation required a Chancery Court judge to be seated in the spring of 2022. This resulted in the legislature funding a fully staffed and operational Chancery Court for 1 year in budget fiscal year 21. During the 2021 session, the legislature opted to move back the date required to seat a Chancery Court judge until the spring of 2023. This allowed the Supreme Court to cut the Chancery Court budget by 50% during the budget crisis. So this leads me to a little bit of a discussion on seating the Chancery Court judge. As I said, currently the statute requires the court or the judge to be seated by the spring of 2023. It's possible that the Chancery Court will take off, but it's also possible that it will take a few years for the Chancery Court to ramp up. A full-time judge may be needed in the next 9 months or may not be needed for a few years. If there is not an abundance of filings, the legislature may opt to move back the date to seat a judge during the 2023 session. So it's possible that we would be looking at legislation then. However, if the legislature decided to do that, the timing would be off because we would already be underway with the Judicial Nominating Commission to select that judge. It takes about 4 months from the beginning to end to get that judge selected. So if the legislature during the 23 session decided to move back the date of that judge, we would already be doing that constitutional merit selection process when that happened. So the legislature may want to consider moving back the date to seat the Chancery Court judge until December of 23. That would give you all time during that next session, during the 23 session, to determine if there is enough filings to warrant a full-time seated Chancery Court judge.
Mr. Chairman.
Go ahead.
Mr. Chairman, Ms. Butler, thank you so much. So I appreciate what you're saying because my guesstimate would be that it's going to take a few years for the Chancery Court to get up and running because the jurisdiction of it is essentially voluntary. It's going to be business disputes. And if you're a defendant, you don't want fast because you owe money. So you're going to object to the jurisdiction whenever you can. And that the jurisdiction will likely occur when there are venue provisions and contracts that get triggered. And those contracts are just now being drafted essentially. So then if we do nothing, if current law stays the same, then is it your understanding that the judicial branch is obligated to fill this seat this next year?
Not this next year, but the year after.
Mr. Chair, Representative Stith, it wouldn't be during 2022, it would be during 23. So during not this coming legislative session, but essentially the session thereafter.
Mr. Chairman?
Go ahead.
Yeah, and let's just have Dawn make a note and maybe something we want to build draft we want to look at. And we can talk about that more. Another question I would, Mr. Chairman, if I may. So I think, if I remember right, I think Judge Finn was one of the three. And so obviously you've got to find another district judge, but the other side of that would be, I think the statute limits it. Does it limit it to 3, or is that a Supreme Court rule on the number of district court judges that serve on that?
And your statute, Mr. Chair, Mr. Co-Chair, the statute does limit the full-time Chancery Court judges to 3, but not the sort of temporary interim stable. I don't think that there's a numerical limit. One of the things we're considering, the district court judges have really made a major contribution to offer to do these Chancery Court cases, and we'll still have the 2, Judge Lavery and Judge Sharp. We may back them up with some retired judges who are highly qualified for this kind of thing. It just, everything depends on the volume.
I think Justice Davis would love it.
Talk to him about that. I'm working on it.
I'm sure Mr. Chairman, I'm sure Mr. Justice Davis has a number of people that already have really good ideas for his retirement. But in doing that, I also just wondering if, I'm saying not necessarily to do that, but have you given any thought to, or would it be appropriate to have, just because if kind of in the state of flux initially, if there was room for a magistrate or something that could take care of some things, because if we've got this 3-judge panel, they have their own caseloads. And so I'm just wondering, would it make sense to have maybe a part-time magistrate that could fill in and do at least some of the preliminary things on as this moves forward?
Mr. Chair, Mr. Co-Chair, yes, it would make a lot of sense. And that's exactly the reason, because the judges already are busy. A lot of the lifting in Chancery Court is going to be just keeping the trains running on time because of the 150-day resolution goal. And I think a magistrate, similar to the way a magistrate works in federal court, would be very helpful in Chancery Court. I actually believe that our chief legal guy, Ben Birmingham, would do an excellent job on that kind of thing. It's so as you know, a lot of litigation gets slowed down with discovery disputes and motion practice. And if we have someone like a Ben to act on those things immediately, that's really the only way to get the speed accomplished that we're looking for in Chancery Court. I don't know if legislation is needed to create a magistrate position or if the judges can simply rely on them informally. That might be something you want to consider.
Thank you.
So I think the main point about Chancery Court that we are working through right now is that it's a moving target. We have no ability to predict what is going to happen with Chancery Court. So we really do need some flexibility to adjust while still remaining fiscally responsible. It's possible if the Chancery Court does take off in the next few months that we may need to come back to you in the supplemental session. We talked about the fact that Judge Fenn will no longer be part of our panel of 3 district court judges who will preside over Chancery Court cases. And if we do need to pull in a retired judge or justice, that will cost additional money. And so for that reason, what you'll find in your budget book on page SC 25, there's a note at the beginning of the exception requests, basically asks this committee to move forward our unreverted funds at the end of the biennium to cover some of the costs of those exception requests. We originally anticipated we would have about $365,000 of reversions at the end of this biennium. Based on some of the shifting that has happened recently, we don't anticipate it will be that much. We do know we will have reversions. We just don't know how much at this point. And that is based entirely on the fact that we don't know the interest level in Chancery Court. So what I will tell you is over the last few months, we have, our vendor has been providing e-filing training and offering e-filing training regularly to attorneys who would like to e-file into Chancery Court. It is required by our rules that they get that training before they're allowed to e-file. We have had about 200 attorneys who have gone through that training. We don't have any filings yet, but they can e-file. And so there seems to be an interest level. We just don't know what the filings are actually going to look like. So again, we'll just we're asking for some flexibility there. And because we don't know our reversions, we would ask that you disregard that note on SC 25.
Mr. Chairman, follow-up question.
Go ahead.
Ms. Butler, just so I understand, let's imagine that we take the suggestion and move the date, say from March 2023 for the Chancery Court seating of the judge to March for a year, say to March 2024. How would that affect the money you need in this budget for your exception request? Would you need less money or do you still want the same money?
Mr. Chair, Representative Stith, I don't believe it would affect our request this time around. And the reason for that is, again, the flexibility that we need. I will tell you, again, if it ramps up quickly, we need the ability or we need some money if we need to hire, for instance, a judicial assistant. We don't have a dedicated judicial assistant right now for the Chancery Court. Ben Birmingham is wearing all of the hats. So he's acting as law clerk, judicial assistant, and also doing most of the administrative work for that court. And so if it becomes unsustainable, we need some flexibility to hire additional staff between now and that time. And so we would request the same amount.
Mr. Chairman, could I add something on that, Representative Stith? If we ask to have the deadline to appoint a full-time judge move back, that doesn't necessarily mean that we have to wait that long. If we need one, we would start the process sooner if we had the funding. The important thing to remember is March is a bad date for the requirement of having a judge in place. The reason for that is it takes the Judicial Nominating Commission process at least 4 months, right? So we post it, expressions of interest, we give 30 days, then they're about 30 days to get the interviews done, and then the governor has 30 days. And then usually whoever is going to take that position needs a little time to wind up whatever they're doing. So if you back up 4 months from March, that means we start the process before we've had the opportunity to come to the legislature and say, whoa, maybe we don't really need one yet. That's why we would like to bump it to a December date. Just so we can come to you with some experience under our belt, showing what our requirement is. Thank you.
Go ahead, please proceed.
Okay, thank you, Mr. Chair. So we'll move on to the exception requests within the Chancery Court Division and unit. They basically fall into two pots. One is for salary, and that is an ongoing cost, salary and benefits for chamber staff. And then the other one is for furniture and equipment to stand up the Chancery Court in the Casper State Building. So the first exception request is on SC 25. As I mentioned, currently the judge is required to be seated by March of 2023. This budget is built off of that statutory requirement. We will likely need a JA, a judicial assistant, by then, if not sooner. So we have 16 months of salary and benefits that we need for that time. Some of that funding is in the current standard budget for staffing, but not all of it. If we need a judge or a JA sooner and we have to fill that position, it's possible that we may come back to you during the supplemental session and ask for additional funding for those salaries. The total exception request for this exception is $406,000, just over. The remaining requests are one time and needed to stand up the court over the next biennium. So they entail, and they begin, on SC 25 and extend through SC 26. And they include security equipment, courtroom technology, furniture, and office equipment. So the security equipment is security for the courthouse itself, and we're making an exception request in the amount of $75,000. Courtroom technology is the technology within the courtroom, so audio and video systems to allow the electronic display of exhibits and the like, and that will cost us about $174,000. Furniture for the offices within the Casper State Building at $145,000. And then office equipment, things like printers or copiers, which is just over $9,000, and telecommunications, so phones at $3,800. So the total unit budget request with the exception requests is $1.38 million.
Okay. Any questions?
Mr. Chairman, my question is on the office equipment side. In the Chancery Court, we're buying copier printer for a couple of them for $9,000. And in the Supreme Court Administration Division, we have office equipment for 2 copiers totaling $475,000. If I'm reading it correctly. So I'm trying to comprehend the difference in price. And that would be SC 10 that I'm looking at under office equipment there.
Mr. Chair, Representative
Just a little
Walters.
clarification. I'm sure there's a good reason.
Absolutely, I'm happy to do that. So the office equipment on SC 10 is, you'll see it there towards the bottom, and I could see, but if you look at that lines 0241 and you follow it over, the total request for that exception for 2 copiers is $19,181. That $475,000 is the total exception request for the administration unit.
Go ahead.
Okay, so the next division that we have within the administration unit is the law library. And that begins on SC 28 and extends through SC 31. The State Law Library provides legal research materials and assistance to courts, attorneys, litigants, and the public. It also houses the Judicial Learning Center, which generally sees 1,000 to 1,500 visitors annually, although that has been down during the pandemic. A lot of the content in the Judicial Learning Center is available online, and we have worked with the Superintendent of Public Instruction to promote the Judicial Learning Center with schools across the state. We get quite a few tours that come through. I'm sure you have seen the kids here during session as well, and they generally make their way down to the Supreme Court and tour the Judicial Learning Center at that time. The law library has experienced some pretty substantial cuts over the last 10 years with no increases. And this is despite rising costs for legal research materials, including books and then online legal research access. So as I mentioned in my opening, this is one of the areas that will likely need more funding in the future. It's becoming, we've had to cut quite a few materials over the last few years to accommodate the budget.
Mr. Chairman.
Please.
So are the Supreme Court justices all electronic in their legal research? Because there's quite a few books in the library.
Mr. Chairman, speaking as one of them, I can tell you primarily electronic, but we use the books too, and there are occasions. So for example, not to get too much in the weeds, but if I'm just researching case law, I use Westlaw. But if I want to sort of wallow around in a horn book and try to understand trust law, then I go down to the library because I find that kind of research is easier to do with a book. And each justice has a different approach to research, but I know everyone uses books occasionally, and when we need them, we need them. Of course, it's for the public as well.
Thank you, Mr. Chairman.
Please.
And so as talking about law library and not affecting the budget you've had before, but just generally, have you started to think strategically about just as we look at where technology is headed and where research and those types of things have headed? I mean, overall, what do we do with our, is this not just this law library, but libraries in general? I mean, this whole area is changing, and I'm just wondering if you've started to think strategically about, in the long term, about how the law library functions and where it goes and how we maintain it. At some point, the libraries simply become historical archives at some point because of the way that technology's changed.
Mr. Chairman, Mr. Co-Chair, I don't believe that we have a strategic plan that contemplates the evolution or demise of libraries. We probably need to. As someone who grew up with the books, it just makes me sad to part with them. But it doesn't bother my law clerks, I can tell you. I have to beat them to go downstairs and pick a book up. So good point.
And Mr. Chair, Mr. Co-Chair, I would just add that we do have online legal resource materials that we provide to the public. So we have provided Westlaw access at the Supreme Court that can be used by public access patrons. Basically, they come into the library and they can use our public access terminals and access Westlaw and do legal research. So we have thought about that, and there are a number of research materials that they can find online, and our law librarian knows exactly how to find all of those. And so when we do get a request or somebody needs help with legal research, and a lot of times we do use that Westlaw access. But I echo the chief, the library is maybe my favorite place in the entire Supreme Court building. So I would miss the books. But yes, we have thought about it. We don't necessarily have a strategic plan, but it is something that we've thought about, and we have implemented some of those electronic materials for the public.
If you want to get rid of any books, let me know and I'll come.
Okay, so moving forward on the exception requests for the law library. So that is on SC 30. You'll see the first exception request, and we talked about this in the administration division and unit. This is a position transfer, net to zero, one position from the law library unit to the administration unit.
But, Mr. Chairman, that's just the other half of the one that was in the administration unit. Right?
That, Mr. Chair, that's correct. And then the second exception request, again, is for office equipment. We have an aging copier in the law library that needs to be replaced. That copier was purchased in 2012, and it is a smaller one, so the exception request is for $2,500. So the total division budget request with the exception requests is just over 1.2 million. The next division within the Supreme Court budget is the circuit courts. That begins on SC 32 and extends through SC 68. Circuit courts are statutorily created courts of limited jurisdiction. They are under the fiscal and administrative control of the Supreme Court, which is different than the district courts. Their staffing is also different between the circuit and the districts. So at the district court level, they have a law clerk and a judicial assistant. At the circuit court level, they have neither of those positions. So the clerks of the court work directly under the judges and perform many of the tasks that a judicial assistant would generally perform. Those clerk positions are skilled positions. They wear many, many hats. They have to know a number of different areas, including the law. They have to understand things like garnishments, confidentiality of protection orders, confidentiality in felony sexual assault cases, which is complicated. They have to work well with technology. We have a lot of court automation systems that they have to understand and use. They have to be financially savvy, so they have to understand all of the money that comes into the circuit courts, which is quite a bit, and figure out where that money should go and appropriately account for it. And they have to have good customer service, or at least we hope they do. We try to teach them how to have good customer service. So the clerks face a really steep learning curve when they come in new, especially when they have no legal background, because then they have to learn the language of the law, which is hard. Institutional knowledge and experience is valuable and important. Some of the successes that we've had in the last biennium at the circuit court level is the rollout of Full Court Enterprise, which is the new case management system. We wrapped that up late last year. And then we've also fully rolled out a new jury management system in all of the trial courts throughout the state. Some of the challenges that we face are things that I think the chief has already mentioned. One is employee pay, retaining qualified circuit court clerks and recruiting them has become pretty difficult. And then their workload, they work hard. $52 million passed through circuit courts during the last biennium. That is down because of the pandemic. Sorry. There are 12 units within this division. The first 3 are units that cover all of the circuit courts or pay for costs in all of the circuit courts throughout the state. The remaining 9 are the 9 judicial districts. So those all represent each of the 9 judicial districts throughout the state. So I'll run through the first 3 fairly quickly. The first unit is the Common Jury Fund, and that is on SC 35 through SC 36. We pay our jurors when they serve $30 a day plus travel if they live more than 5 miles from the court. That is statutory. The standard budget for this Common Jury Fund is just over $135,000. And again, that pays for jury fees throughout the state. The second unit is circuit court equipment. That begins on SC 37 through SC 38. This unit covers costs of things like the lease of postage meters and copiers for the courts throughout the state, the circuit courts throughout the state. As you'll see, we have an exception request here on page SC 37. 5 of our courts need new copiers. So our total exception request for this is just under $40,000. It's a one-time request. So the total standard and exception request for this unit is just over $91,000. The next unit is the examination of courts, which begins on SC 39 through SC 40.
Go ahead.
Thank you. I'm just curious, we're seeing a lot of copiers and the prices seem to vary. I mean, within a tighter range. Have you looked into bulk purchases and for the procurement?
Mr. Chairman, Representative Schwartz. No, we haven't looked as far as a bulk purchase goes. For each of these courts, they went to several vendors, got quotes, went with the best quote that they have. It does vary though, because some of them have different needs. So it might be a copier that they're primarily using for printing. Another one, it might be scanning as well and things like that.
Okay, so the examination of courts units begins on SC 39 and goes through SC 40. That employs 2 full-time employees. One is an audit services manager and the other is an accounting analyst. These 2 basically help with the financials that run through the circuit courts. And so one audits those to make sure that no funny business is happening. And then the other one provides a lot of financial support to the circuit courts as they're dealing with that money. The standard budget for this unit is $476,000, and we are requesting that amount. The remaining 9 units represent the 9 judicial districts throughout the state. Mr. Chair, with your permission, I would like to just hit on the exception requests in those circuit courts, unless you would like me to run through each one of those 9 units. They are very similar.
Okay.
Okay, so within those remaining 9 units, there are 3 exception requests. All relate to telecommunications and are based on ETS's 2022 and 23 rates, cell phones for traveling judges, increases in language line costs, and rises in carrier costs. So you'll find the first exception request on SC 48. And that is for the 3rd Judicial District, which encompasses Sweetwater, Lincoln, and Uinta counties. Again, this is telecommunications cost. This judicial district uses the language line to provide interpreter services to people who come into the court quite often. It's pretty difficult to find interpreters sometimes down in the southwest corner of the state. So they use that language line. And so the costs have increased. And that is one piece of it. And it also encompasses a cell phone for a judge there who travels between 2 locations. That total exception request is $4,800. The next exception request is for the 6th Judicial District, which is on SC 57. Again, and this judicial district encompasses Campbell, Crook, and Weston counties. Again, this is just for telecommunications costs, fees billed through ETS for independent carrier coverage, and they're expected to increase based on what we've learned from ETS. So that exception request is for just over $1,900. And the final exception request within this division is on SC 63. And that is for the 8th Judicial District, which encompasses Goshen, Platte, Converse, and Niobrara counties. Again, telecommunications cost, cell phone, and increased costs associated with fees billed through ETS. So that request is for $2,900. And Mr. Chair, if there are no other questions, this completes the Circuit Court division.
Okay. Other questions on circuit court? Okay.
The next division is the Court Technology Division. That begins on SC 68 and goes through SC 75. Our court technology is funded through 2 different sources. One is funded through the Court Technology Unit, which is allocated general funds. The other is through the Judicial Systems Automation Unit, which comes from special revenue funding that is fees assessed through filings in the courts. Those 2 funding sources support technology advances for the entire judicial branch. It includes personnel costs for 8 IT staff and 9 application staff, costs related to cybersecurity, internet, technology equipment, the judicial branch network, cloud storage, and software applications like the case management system, e-filing system, and jury management system. It also pays for courtroom technology and various licensing costs. The successes of our court technology over the last biennium include the ability to seamlessly transition to remote court hearings during the pandemic. We were also able to leverage CARES Act funding to provide additional courtroom technology to enhance those remote hearings, and the full implementation of the new case management system in the circuit courts, and as I said, the jury management system in all trial courts throughout the state.
So could you provide us quick numbers of how much CARES Act or other COVID-related funds you were able to receive and what they were used for?
Mr. Chairman, with CARES Act funding as it relates to courtroom technology, we received approximately $6.7 million for things like audio and visual system upgrades. And then an additional 1.2 million for jury room adaptation. So getting hubs and things like that so that we could distance our jurors instead of having them sitting one right on top of the other.
And do you have any other pending requests other than the ARPA dollar requests?
We do not, Mr. Chairman.
Okay, thank you.
Mr. Chairman,
Go ahead.
Ms. Butler, if I could go back to the circuit courts just for a moment. I have a question about circuit court part-time magistrates. Two-part question. One is the current state of the law is a bit odd in that if you want to get rid of a magistrate, you need the consent of the county commissioners, which is just strange. But my question is, first off, where in the budget do I find the line item for the circuit court, those part-time magistrates? Is that, I just should do my homework better. The next question is, do you need them?
Mr. Chairman, Representative Stith, the funding for those magistrates there's the same with the clerk. So in Object Code 0103 in each of those districts. So they're treated just as an employee, counted as an employee.
Just trying to follow up, but I take it those positions aren't separately identified here in the budget. Is that right?
Mr. Chairman, Representative Stith, that is correct. They are not separately identified.
Chairman?
Please.
So we used to have every year we were talking about a significant backlog in courtroom upgrade technology. And so with the application of the money from the CARES Act funding that's applied, where's that backlog now? Is it how much of that got taken care of with respect to the CARES Act?
Mr. Chair, Mr. Co-Chair, essentially all of it. We upgraded all of the courtrooms throughout the state. I think the only one potentially that we have left is Carbon County, and that's because they are currently renovating their courthouse.
Is there money set aside for that, or did it have to be, did you run up against a deadline and so Carbon County didn't do that?
Mr. Chairman, Mr. Co-Chair, that's correct. For CARES Act money, it has to be in place by December 30th of this year. So we will turn to our JSA funds for that.
And then how are we coming along with the technology funds that when we've increased the fees over the last few years? How's your balances doing, and what's your plans for the future uses?
Mr. Chair, so that is part of the Judicial Systems Automation Unit, which is on SC 73. And what you'll find there, we generally at the judicial branch, we do a 10-year projection of our court technology budget. And mostly because we have salaries in that unit. And then also because we need to make sure that we're looking forward when it comes to technology and making sure that we can maintain what we currently have. So what you will find there is that in budget fiscal year 27, we will be looking at the current rate of filing fees that we anticipate that fund will start to get depleted, that we'll use it up for various things, including the court automation systems we have in place, keeping up with courtroom technology and other costs associated with court technology throughout the state.
Please.
And so as you look at the chart on page 73, and you see the JSA fund balance line drop off, is that because you have, is that part of the technology replacement anticipation that the useful life of the stuff that much of the stuff has been bought last year and the year before and last few years, that falls off and that has to be replaced? That's what the big dip is.
Mr. Chair, Mr. Co-Chair, that is correct.
Okay, thank you.
All right, I'm going to move back a little bit to talk about the exception requests within the court technology budget. So as I mentioned before, the court technology budget or the court technology unit is a general fund unit. So this is money that does come out of the general fund. We're on pages SC 70 through SC 72. The court technology funds some day-to-day operations of technology like the internet. It also has 3 employees within that unit. The standard budget for that unit is $2.6 million, and we have 2 exception requests. The first exception request, the Chief Justice has already addressed, and that is for the combined case management and e-filing system for the Supreme Court. That system is over 12 years old, and it is really starting to show its age. It has worked very well for the Supreme Court over the last 12 years. If you all remember, this body appropriated money for the replacement of that system in the budget fiscal year 21, but that was delayed due to the 2020 budget crisis. And so we are back again to request that money so that we can replace that system. Before Wednesday, the Supreme Court was the only court in the state that you could e-file into. We now have the Supreme Court and the Chancery Court, but we don't want to lose that ability at the Supreme Court level. And we're reaching a point where we are using duct tape to keep it together.
Thank you, Mr. Chairman. Common question we ask our agencies is when we get to the maintenance and support agreements, and are just curious what kind of conversations you've had with the vendor to negotiate that. That's a biennial number. I'm assuming the 30 grand would be ongoing. And so then what are we getting for that? And then was there any effort to bring that down? We just struggle with those.
Mr. Chair, Representative Larson, so that we are not under contract yet for that new case management e-filing system. So that is something that we will negotiate. I think this is an anticipated ongoing cost. Generally, with our contracts that have ongoing costs, we do build in escalators. So you can't go above a certain amount within a 5-year period. And we do everything we can to keep those as low as we possibly can. The other piece that ongoing, I think the second part of your question was, what does that ongoing cost provide? And it is updates to the system. So when we implement a software system in our courts, it is active, for lack of a better word, for a certain period of time. And it's what the vendor chooses. So 5 years, 10 years, whatever time frame that is, until they create a new one. During that time frame, they provide continual updates to that software. So you get added functionality. You also get added patches and things like that to make them more secure as we learn of cybersecurity threats. So that ongoing cost pays for that maintenance and support. It also pays for potential issues with the system. If we find bugs in the system that need to be corrected, that ongoing cost provides for those kinds of.
Chairman, so then, in course, all of that sounds reasonable, but then because we ask, so then in the course of the year, how many updates will you receive? How many? So, with what your explanation, I would think that maybe on a monthly basis, upgrade or would be something. But then, if the reverse of that is what if we don't do it?
Mr. Chair, Representative Larson, it's entirely dependent on the vendor itself to determine how much they're going to develop that system. Some vendors do can do monthly upgrades and changes to the system, and some vendors don't. So it's just hard to quantify.
Chairman?
Mr. Coacher.
Thank you, Mr. Chairman. So you go out, I don't know how specialized this software package is. I mean, as you look at how many, are there multiple vendors that you can go and look at for the appellate case management system software?
Mr. Chair, Mr. Co-Chair, we have looked at different vendors. What we have learned is that there is one leading vendor in this area for appellate, this combined appellate case management and e-filing software. And it is the vendor that we use currently for our current system, and that is Thomson Reuters. So we have talked to a number of different states about what they use, and most, I don't want to say all, but many of them use that upgraded system of C-Track, and they seem to like it. I think it is a leader in the industry in that regard. I think there are others, but I don't think they are quite as well liked as the C-Track system.
So with that, are you going to be required to go out with an RFP, or are you just going to sole source it back and upgrade what you have?
Mr. Chair, Representative Larson, I would imagine we would try to go out to RFP. If there are other vendors, I think there are other vendors in the industry. We did that when we did the e-filing system, when we contracted for the e-filing system at the district and chancery court level.
So Carrie Jo, do you need to borrow anybody's sunglasses while you're sitting back there? Okay. Go ahead.
Okay, so the second exception request within this unit is for basically telecommunications costs. We have moved some of our staff to the Hirschler to perform their services. And so we need additional phone lines and some cell phones. They do quite a bit of traveling. These are the folks who actually go out on the road and roll out those court automation systems. So they spend a substantial amount of time on the road. So that request is in the amount of $5,500. And if you're looking for it, I forgot to say the page number, it's on SC 71. So the total unit budget request with exception requests is $4.3 million for this unit.
Elisa, I've got a couple questions just on some of the things we worked through. Going back to SC 21, the $17,000 for travel and ongoing for travel. The narrative doesn't really indicate whether or not you want that to be ongoing or if that's a one-time need.
Mr. Chair, on SC 21 for the Judicial Nominating Commission Division and Unit, we would request that that be an ongoing cost.
Okay, and then on the $20,000 at page 73 on in-state travel. Was that ongoing or one time?
Mr. Chair, can you tell me the page number again? I'm sorry.
73? DC 73.
Oh.
And while you're looking at that, I do have a question on SC 37. In your submissions to us, you did not provide what we call the D sheets. And the D sheets they illustrate the compensation, benefits, et cetera, by position for all of the exception requests. And I think that LSO particularly would like to get those D sheets or have them so that we understand and have a breakdown of it. Does that make sense? Am I articulating that correctly, Don? So would you get together with, just so we can make sure that we get those D sheets?
Mr. Chair, we will.
Okay. Okay.
And Mr. Chair, if you would like to address DC 73 now, I'm going to let Claire talk about that.
Mr. Chairman, so DC 73, this is our district court in Jackson. And as you know, it's expensive in Jackson. The judge there is retiring, I believe, in February. And we So his replacement is possibly going to come from within that area. So it is likely that he will have a lot of conflicts that require other judges to come cover the cases. So what you see on 73 is a one-time request to help with the travel costs that they anticipate early in this new judge's career.
Okay, we need to know. Thank you. Okay, please proceed.
All right. So we are on SC 73. And this is the Judicial Systems Automation Unit within the Court Technology Division. We've already touched on it a little bit. This unit funds everything that is not funded by the Court Technology Unit. It was statutorily created in 2000 to cover court automation. So basically software systems leading to e-filing. It was expanded in 2018 to cover courtroom technology costs. It brings in, so these are fees, as I said, that are assessed on filings within the courts in the state. It brings in $6.4 million per biennium. It pays for the salary and benefits for 13 employees, which amounts to about $3.1 million. The balance is just under $7 million. And as we discussed before, the 10-year projection indicates that the fund will likely be inadequate to cover the costs that are currently being paid out of it by budget fiscal year 27. There are no exception requests for this unit, and we would ask for the standard budget spending authority in the amount of just over $7 million.
Go ahead.
So is it just Series 100 stuff, or do you take care of technology components as systems as well?
Mr. Chair, Representative Larson, the funding that comes out of here, it funds a number of systems that are used throughout the state, and it also funds courtroom technology generally.
So then, I guess the question is, so then you're contemplating how you will adjust to meet the decline in revenue, or?
Mr. Chair, Representative Larson, I think we're looking at different options to do that. Depending on the policy set by this body.
Mr. Chairman?
Go ahead.
I mean, if you look at it, it's not that the revenue declines. I mean, it's just the case filings are likely to, if Wyoming is successful and continues to grow, those case filings are going to go up. So the revenue stream doesn't go off. What happens is anticipate there must be replacements happen at the end of 10 years. That's why it's insufficient, because you have all the stuff, new stuff that has to be replaced. So you look, those lines of the outgoes and the inflows go like this, because we're just going to get dependent on, that's when it's going to happen. And it's one of the things I think when we talk about this, I mean, there's ways to handle that. We can develop an appreciation reserve. There's no, or you can, there's a sinking fund, or you can just appropriate when you need it. So that we've got options how to do that. We may talk about some of those when we get down to the budget markup.
Okay.
All right, Mr. Chair, that completes the Court Technology Division. The next division is Judicial Retirement. That begins on SC 76 through SC 78. There's nothing new here. This is the standard budget request. This is a precursor to the judicial retirement plan under the state retirement system. So there are only a few people who are still eligible under this plan. It is dwindling and will eventually go away. The standard budget request is for $1.8 million.
Okay. Next.
The next division is branch-wide resources, and that is on SC 79 through SC 81. So this unit used to be known as the Board of Judicial Policy and Administration. We have changed the name of the unit to be a bit more transparent. I think the Board of Judicial Policy and Administration, nobody understood what that meant. Branch-wide resources really describes what this unit is used for and has historically been used for. It is used for costs that are needed throughout the entire branch. So it covers things like legal research resources, so Westlaw access to the judges throughout the state and their law clerks, judicial education, treatment court magistrates, and payouts for sick or annual leave if individual budgets fall short.
I think you should have called it ranch wide. It'd been more fun.
So the standard budget for this unit is just over $616,000. And Mr. Chair, this completes the Supreme Court budget request.
Which leaves us a perfect amount of time for your ARPA explanations.
Perfect. Thank you, Mr. Chair. And I'm going to let Elisa talk about those as well.
Okay.
So, Mr. Chair, we did submit some materials for our ARPA requests. As I stated in my opening, the 23-24 judicial branch budget represents the funding needed to maintain the operations of the courts. The ARPA funding requests I will present, on the other hand, are new opportunities for this committee to consider that will allow the courts to better serve the people of this state. So what you will see are two sets of requests. The first are requests that have not been presented to the governor. The second are requests that have. At the time, as of today, the governor has not yet approved the requests made to his office, so we will talk to you about those as well. And you will also see at the beginning of this document that it says preliminary, and that is why it is preliminary. We're waiting on those requests that were submitted to the governor and get some answers on those. Once we know that the status of those requests, the formalized request will be delivered to this committee with a letter from Chief Justice Fox. So starting with that first handout that says preliminary at the top and has the date of November 2021, you'll see the first request there is for circuit court e-filing. This, during the last budget session, the court was appropriated money for e-filing in the district and chancery courts in the state, but there was no appropriation for circuit court e-filing. So we currently have no budget for that, and it would create substantial efficiencies for the courts and the litigants, similar to both the district courts and the chancery court in Wyoming. I think in the past, there's been some concern that if we rolled out e-filing in the circuit courts, it would somehow interfere with the rollout in the district courts. And based on the timing that we have to spend ARPA requests, we don't anticipate that that will be a problem. So the total request for, or the total amount for this request is $2.1 million.
What would be the ongoing cost once it's up and running?
So I believe we received a quote for circuit court e-filing a while back, Mr. Chair, from the vendor that we're using for the district courts and chancery court. And I believe the ongoing costs that they quoted us, we are not under contract, we're not insubstantial. So it looks like maintenance and support, they quoted at $400,000 a year. Again, we're not under contract, so that's just a quote that we received from the vendor that we're currently using.
And would this system be interactive with all other e-filing systems? So you can follow and cross-pollinate with district court, Supreme Court?
Mr. Chair, it would in a sense. So when you go into the e-filing system, what would happen is you come into a portal, you log in, and you select the court that you want to e-file into. So if we chose the same, if we selected the same vendor that we have used for the district courts and the chancery court, it would be the same portal. It would be the same process. It would feel and look exactly the same, regardless of the court that you're filing in, which trial court you're filing in. But again, that would be dependent upon us using the same vendor for the circuit courts that we've used for the district and chancery courts.
Well, you know, in a far dreamy, distant future, the circuit courts and the clerk of courts could actually be doing kind of the same functions, because and you would think then it would make sense to have them have comparable or, you know, mirror type of programs so that you can move from one to the other. It just makes sense to me.
So at the end of the day, I guess the goal kind of like Pacer, the EF, the federal filing system, but better.
Mr. Chair, Mr. Co-Chair, yes.
Okay.
So the second request is for temporary time limited trainers.
So the 2.1 million, though, that's just for the startup, not for ongoing costs.
That would be ongoing costs through 2026. So it would be this, the initial implementation, Mr. Chair, would be, we got quoted at $540,000. The second request is for temporary time limited trainers. So as I mentioned before, one of the things that we have noticed that we struggle with because we don't have enough people is training our circuit court employees. As I mentioned, they wear many hats. They have a difficult job, and there are a lot of moving pieces. So most of our circuit court clerks right now are learning that job on the fly. They come into the court and they just get handed a pile and say, here you go. So what we would like to do with these temporary time limited trainers is basically send them out to the courts as train to help those courts become more efficient. The clerks learn their jobs when they are new, and then also potentially to fill holes when we have a lack of staffing in some of the circuit courts due to like an FMLA issue or, turnover in a certain court. So they would be able to help us kind of shore up some of the both the training issues and potentially some of the staffing issues that we've seen in the circuit courts recently. So that request, and that would be positions through 2024, and the amount is $888,000.
Go ahead.
So you have those as time sensitive or time limited. Is that, are you saying at the end of that time, we won't need them anymore? Or are you anticipating that to be ongoing, funded from someplace else? And that's my first question. And my second question is well, that'll probably, that's.
Mr. Chair, Representative Larson, I will tell you, ideally, we would be able to keep those. I don't think there's ever going to be a time when we don't need people to train on how to do a clerk's job. And that is simply because it's a difficult job. And so ideally we would want to keep those positions. But when we come to 2024, if we don't have the funding, we won't keep them.
Oh, Mr. Chairman. So do you ever use your veteran court clerks to help train?
Mr. Chair, Representative Larson, we absolutely do. Some of the courts and probably Judge Christensen has participated in this recently, will send their chief clerks, so that's like the clerk of court, to another location to help train new staff. And that happens pretty regularly. The problem is they still have their workload at home. And so when they go out and train another staff, they leave their court a little bit in the lurch, and there's a buildup of work that needs to be done. So if we had dedicated people to provide that service, it would ease some of the workload for those courts.
Thank you.
Mr. Chairman?
Go ahead.
Mr. Chairman, can I add something to that
Of course.
response? There is a time limited feature to these trainers. Of course, we would like to keep those positions and we think they're important, but if we get circuit court e-filing within the same time period, that would reduce the workload that is added to our circuit court clerks right now of scanning documents. And so there is a little bit of a fit time-wise if we get circuit court e-filing. By the time that is accomplished, as I said, we'd still like trainers, but it might relieve some of the load on those circuit court clerks. Thank you.
Mr. Chairman,
Go ahead.
Ms. Butler, with respect to the circuit court e-filing, I'm, as you might imagine, strongly supportive of that, right? And when we try to sell this to our colleagues in the two chambers, one question we may get is, what's our plan for the $400,000 per year estimated cost after ARPA funds are no longer available? Is it contemplated that there will be any pay-to-play feature with respect to this e-filing? In other words, personally, I don't want that. I want to use it for free, right? But if you say go to the California court system, if you want to retrieve a court document, you pay $5, you pay $10, whatever it is. Any contemplation of that for our e-filing system.
Mr. Chair, Representative Stith, it's true in other states, they charge per filing, right? So there's not just one-time filing fee at the beginning of the case. Every time you file, you get basically a document charge. It is possible to do that within the e-filing system that we're using in the district and chancery courts. We are always a little bit reluctant to impose additional fees on people who really need to use the courts to help resolve their issues. But it is a possibility.
Mr. Chairman?
Go ahead.
Thank you. Just going back a little bit, like I say, I'm always trailing just a little bit. On the e-filing for circuit court e-filing, I understand, I just want to make sure I understand that what we started out with was the initial cost was $540, and then it's 6 years of maintenance. That's the total ask right there. Is that how that's compiled?
Mr. Chair, Mr. Co-Chair, that's correct.
All right, my math worked out. Thank you.
Could you do some calculations for us? Even though you're hesitant to make charge fees, we are not. Because it's one of those things that I think you've got to pay to play to do certain things. And so if it's a $5 fee, what would that generate? Kind of like we did in the circuit court or the district courts for various fees, so that we can pen that in. And it's also, to some degree, it makes sense that the counties have to have a little skin in the game. And we're going to have that issue again when you get to court security. Just because if we don't share the load, then we carry all the load. And so I think it's, one of our principles is that everyone needs to have some type of skin in the game to make this all work and to be responsible for it. So I think that would be useful if as you're putting this package together, we could understand what that could be.
Mr. Chairman, in just doing that, I think, we looked at that a little bit back when we were working on Chancery Court about filing fees. And so what I would suggest is you maybe find a state that does electronic filing or a court that does electronic filing. You think it's relatively similar. And then I don't do a detail, but if you can make a decent swag on taking that fee structure and putting it into our circuit court filing system and just see what that looks like. So like I said, I don't want to, I'm not talking about a spreadsheet that goes 6 pages. I'm talking about just kind of figure it out and then just make some assumptions. Let us know what the assumptions are and just give us a run of what that looks like. Does that make sense?
Mr. Chair, Mr. Co-Chair, we can do that. The third request is for courthouse security. So many courthouses throughout the state are in need of security updates to protect judges and staff in those courthouses. They do provide a valuable public service, and that can often make them a target. So what we would request for courthouse security is the amount of $2.175 million to shore up the security needs of the courthouses across the state.
How did you come up with 2.175?
We looked at the number of courthouses we have in the state and we multiplied it by $75,000.
Okay.
When we do that, I mean, if you go around, Cheyenne's done, Casper's got theirs, you've got, Rollins is in the middle of doing theirs, Buffalo's redone theirs, Gillette's done theirs. So, I mean, are we talking about, why would we do additional grants to those counties that are already upgraded? And then, anyway, just wondered about the logic on some of that.
Mr. Chair, Mr. Co-Chair, I think we were banking on the law of averages. And so there are some courthouses throughout the state who do have fantastic security. And there are some that need much more than $75,000 to shore up their security. So it wouldn't necessarily be a grant of $75,000 to each courthouse. It is just a way that we could come up with a number to accommodate what we think is needed throughout the state.
Okay.
What's been your practice in requiring matching dollars from the county for the courthouses for security?
Mr. Chair, so I don't know exactly what the practice has been as far as match in the past, but we did receive, our SLIB had some funding, was appropriated some funding in, I think, 2014, 2015 for courthouse security. That was provided to, I believe, Fremont County and one other county to basically build a new courthouse. And then we were there was about $400,000 appropriated to the Court Security Commission, I think in 2018, to grant out to counties to allow them to, upgrade their security. I can't tell you off the top of my head what the match was, but there was a match for that $400,000. I'm not sure about the SLIB money, but we can definitely find that and get those numbers to you.
Okay, thanks.
Mr. Chairman,
Please.
Ms. Butler, so I should have read this more carefully probably, but so this $2 million for courtroom security will that be like a pass-through grant to the counties then? I mean, or because I assume it's not contemplated that the Supreme Court's going to hire a new, security officer to go around to the courts. I mean, not recently in the last year or so, I had a civil case where, my client, a civil defendant in a case, the good judge used the deputy sheriff to put my client in handcuffs, which was, as it turns out, appropriate. But I assume that the Supreme Court's not going to be hiring new people. How's this money actually get used?
Mr. Chair, Representative Stith, that is correct. We don't contemplate hiring anybody new at the Supreme Court level. It would basically, I think it could take one of two routes, and one would be similar to what we did with the Court Security Commission, in that we would grant that money out to the counties, and even potentially they could provide receipts and request reimbursement for funding.
Okay, let's move along.
All right. The next request is for data sharing interfaces. So that basically what that is we're looking at providing additional information to state agencies. One of the things that we have recognized recently, and more than recently, is that data is becoming incredibly important, and often it becomes siloed. And so we would like to share the data and make it more effective and efficient as much as we possibly can. There are 2 state agencies that we've identified currently that we could, provide additional interfaces with our system and their system that would make things more seamless. And that is DCI and Vital Statistics. We currently feed information to DCI nightly right now. The way the systems work, they don't really talk very well. And so this would upgrade that interface so that would make it more seamless integration of information sharing between the judicial branch and DCI.
Did you go out to the vendor and get a bid for this?
We did not. How
did you come up? Is it a swag?
Yes, Mr. Chair. The second is for Vital Statistics. The clerks of district court are required to provide certain pieces of information to Vital Statistics when they have things like divorces, adoptions. And so if we could create an interface with Vital Statistics, that information again could be shared more easily and would cut down on the legwork of the district court clerks to deliver that information to Vital Statistics.
Go ahead.
Mr. Chairman,
Go ahead, please.
this may be a question for you or for the Chief Justice. Is this intended to address the issue that we touched upon with the head of the governor's task force on impaired driving, on their need for data on disposition of cases?
Mr. Chairman, Senator Kinski, it may assist in that matter, but it's not going to fully address it. So that needs to go, I believe, to DCI or to, DCI and corrections. And I think the kind of data that you're looking for, and not to get too far afield, will need to come from various sources, not just our courts, our circuit and district courts, but also the municipal courts and corrections. So I think we're going to need further interfaces to accomplish what you were looking for.
Mr. Chairman,
Go ahead.
might you consider some of this funding to at least outline what the tasks are and the to-do list? Maybe we can start getting a price on that.
Mr. Chairman, Senator Kinski, we certainly can do that. We'll need to work with various agencies to get that accomplished.
Thank you, Mr. Chairman.
Chairman?
Go ahead.
Thank you, Mr. Chairman. The 1.5 is one time, or would there be ongoing costs after?
Mr. Chair, Representative Larson, I don't know the answer to that for sure. I can tell you that our feed to DCI right now, there's no ongoing cost. We're not under a maintenance and support agreement for that. But I don't know the answer to that off the top of my head.
Mr. Chairman?
Go ahead.
And so on this, with the data mart and this whole concept, what kind of interface does our court system, case management systems have with DFS and Department of Health with respect to particularly juvenile or various juvenile issues that the courts are dealing with and we're dealing with across state?
Mr. Chair, Mr. Co-Chair, I feel a little bit like I'm in joint judiciary right now because we've been talking about this during the interim quite a bit, but we don't is the answer. That's the short answer. We don't have any interfaces right now with DFS or with the Department of Health. During the last joint judiciary committee meeting, DFS spoke about the fact that they are looking at a new system themselves and looking to get an upgrade to theirs. And it's my understanding that that system actually contemplates a data feed from the judicial branch into that new system. So I think that is part of their scope when they did their RFP or RFQ, but Director Schmidt would know much better than I the specifics of that.
Well, and thank you. And Mr. Chairman, I've had discussions on this with Department of Health, Department of Family Services, and so now you're here as well. But I mean, one of the things we found out as we looked at this is we have no ability to trace an outcome of a juvenile across all the state agencies that touch the lives of those juveniles. And somehow, some way, we've got to put this together. And I'm sure that there's bright people out there that can figure out how to provide the privacy that needs to happen in that. But ultimately, somehow, some way, we've got to trace out. Otherwise, how are we going to ever trace and find out the outcomes we have of the millions and millions of dollars that we're rightly putting in to try and save some of our youth from themselves? Thank you.
Okay, let's wrap it up as we can because we're a little over time.
Okay. So the next request is for lost positions. During the budget cuts, we lost 3 positions. As I mentioned, when we were talking about some of the future needs, the administrative staff is definitely in need of additional positions. That cost would amount to $1.1 million. Mr. Chair, I don't know, the second piece of these ARPA requests are requests that have gone to the governor. If you would like me to go over those, I'm happy to do that.
Those will go to this, went to the strike team.
They did, Mr. Chair.
So, and I've looked through them. I'm on that strike team, but if you want to just briefly touch on them, just tell us what they are.
Sure, Mr. Chair. So
Mr. Chairman, can you go back? You said on that funding request for those positions, how much? I was on page 5.
681.
I'm sorry. I have the wrong number on my notes.
Keeps growing.
Mr. Chair, $681,000. My mistake.
And that lasts for,
It is budgeted through 24.
yeah. And then you wouldn't come back and ask for more money, would
Mr. Chair, I cannot make that promise. So the requests that we sent to the governor are, they're basically 2 requests. One is for Equal Justice Wyoming. Equal Justice Wyoming provides free civil legal services to people in need across the state of Wyoming. So these grant requests or these requests really do shore up and provide additional support for that program and provide additional support for the citizens of Wyoming. The first would be additional grants to providers throughout the state so that they can provide additional services to people in need. The second would be to fill an Equal Justice Wyoming position. They've had a position that has remained vacant for a while because their special revenue fund, which is where all the funding for Equal Justice Wyoming comes from, has gone down. The revenues have gone down, and so they have not filled that position. So they're requesting funding to fill that position. The third is for a common case management system for the providers. So what Equal Justice Wyoming does is they receive grants and then they provide grants to providers throughout the state. So those providers actually do the services needed or provide those services to the people throughout the state who need them. And so the common case management system would be for those providers who are working under those grants. And so they would be able to provide data to Equal Justice Wyoming in terms of what they're doing and what they're seeing. And then also, if they were using a common case management system, they could easily transfer potentially clients that need to go from one provider to another.
How does this tie into the UW's clinic program? 'Cause they provide roughly $2.5 to $3 million worth of legal services for those in need across the state for different type, and it's usually victim-based or income-based, the services they provide. How do these kind of things cross-pollinate?
Mr. Chair, I may have to phone a friend to answer that question. So Angie Dorsch is the director of Equal Justice Wyoming, and she would be able, I think, to address that better than I.
We'll make her sit in the sunny spot.
She wants to stay in the back.
Mr. Chair, thank you for that question. And yes, the UW clinics are a huge provider of legal services, and we would anticipate that we would offer them to be able to be on that system. We don't grant them specifically through Equal Justice Wyoming. However, our foundation arm, our 501c3, does provide grants, substantial grants to the University of Wyoming clinics. And so we would want them to be able to also utilize that to be able to transfer cases and make case transfers.
Okay, thank you. So this grant basically is a time limited grant through the 2026 again. And then we'll be stuck in a rock and a hard place on, do we continue it or do we not continue it? Is that fair?
Mr. Chair, I think that's a fair statement, although as you know, the funding for Equal Justice Wyoming does not come from general funds, so it'd be special revenue. I mean, potentially, but yes, potentially we'd be looking at figuring out how to fund that in the future.
Okay.
The next request for Equal Justice Wyoming is an online legal triage portal. Basically what this would do is it's an automated online questionnaire for people who qualify for these civil legal services, and it's going to help the clients find the most appropriate resources for whatever issue they're facing. And the final request under EJW is a enhancement of the website, the Equal Justice Wyoming website. So the website for Equal Justice Wyoming really does provide a hub for civil legal services throughout the state. It services not only the clients, but it allows for attorneys who are doing pro bono services to do things like training. And so this would allow them to enhance that website and provide an upgraded site for people who use it. And then the final request that went to the governor is remote interpretation software. So what we have experienced as we have moved to a more remote world in the judicial branch and having remote hearings is interpretation becomes incredibly difficult. Unless you have something that can allow the interpreter to mimic what they do in the courtroom, which is basically whisper in somebody's ear, it becomes really long and really complex. And so what's happening right now is a lot of the courts are having remote interpreters, and they may have a remote defendant or a defendant in the courtroom. And basically every word has to be translated out loud. So it takes substantially longer to deal with those cases and those kinds of hearings. This software would allow kind of mimic that whispering in the litigant's ear or the witness's ear, instead of having to stop and translate in real time everything that's happening. So that is what the remote interpretation software would enhance, basically our ability to have remote hearings and include interpreters in those hearings without disrupting the proceedings. So the total amount for that is $375,000.
Okay. Any questions on the ARPA dollars requests? Chief Justice?
Mr. Chairman, thank you.
Everyone's pointing around. Oh, go ahead.
Couple of things. One, I didn't move away from Elisa because she's talking about ARPA. We fully support the ARPA request. And finally, just thank you for your time and attention. We appreciate it.
Thank you.
Thank you.
Thank you for being here. We know it's, you live to come do this, I know. It's nice to see everyone. Don?
Mr. Chairman, the governor has submitted his budget request, which contemplates the usage of ARPA dollars in the Department of Corrections and the Department of Health, for example. As the court's proposal identifies, they appear to be including some ARP monies from the provisions for government services or revenue shortfall funds and other priorities. For example, the first one appears to be an IT request that may be eligible for strict ARP dollars as opposed to the conserved ARP dollars. The committee might be interested in which of those two categories the variety of requests fall into when you commence your markup.
Well, and my guess is that the strike team will identify those and place them, presumably. If the and I don't think you care where the money comes from as long as you get it.
Mr. Chair, yes.
But some is easier to pan out than others. So, and there's for the free dollars, there's already $3.5 billion in requests out there, and more coming. And there's also, just so everybody knows, I think there are legislative ideas as well on top of that, some of which is to save a lot of it and not do anything for now. But, so it will be an interesting couple months. All right. Thank you, everybody. We'll take a 15-minute recess, come back at 10:30. Okay, we are back. And next on the agenda are the district courts. So welcome, Judge Lambury. Please proceed.
Thank you, Mr. Chairman. Members of the senators and representatives of the Joint Judiciary or Joint Appropriations Committee, thank you for allowing me the opportunity to speak to you today and answer your questions about the 24 district court judges that sit around the state of Wyoming. I want to talk a little bit about who we are. I'm sure most of you know, but we are the constitutionally created general jurisdiction trial courts for the state of Wyoming. We hear all the felonies, estate probates, adoptions, guardianships, conservatorships, juvenile abuse, neglect, delinquency, and chins. We hear mental health and voluntary commitment cases, all of the civil cases involving claims of more than $50,000. We hear appeals from circuit court and from administrative agencies, and we can convene grand juries. Each of the 24 district courts is its own separate state agency responsible for its own budget and administration. Now, when I say that, there's some things that probably need to be understood. Sure. In this day and age, it's not that much fun. Tell them to stay back. So I want to tell you that while we are each separate and independent, we rely so much on the judicial branch and at budget time on Claire Smith and the people in her office as the chief fiscal officer for the branch. None of us could do our budgets by ourselves. When budget time comes around, we each work on our own separate budgets because we are so different between judges. Some of us have travel issues, some of us have people issues, but it's something that we work with both our budget committee, which is made up of the executive offices of our judges conference, and with Claire and her staff. We couldn't do it without them, and that's true in so many ways. We like our independence, but we are not independent, and that has happened so much over the last few years because of technology and because of the things that bind us together that are much more important than the things that separate us. All of our technology needs are met by the technology office of the Supreme Court. And we rely on help from Elisa Butler and her people, and as I said, Claire and her people. And so as much as we're independent, we're very dependent on the help from the Supreme Court. With a couple of exceptions, each judge has 3 additional employees: a judicial assistant, a staff attorney, and a court reporter. The vast majority of our budgets are people. I would say 95 to 97% of our budgets are based in salaries and benefits. So it's a small amount that's used for things like paper and copiers and things of that nature. As an example, my budget is approximately $1.13 million for the next 2 years. My non-salary and benefit budget is just under $29,000, or about $14,500 a year. I try not to spend that if I don't have to, but I don't get to choose that. We're reactive. If I need interpreters, I'm going to spend money out of that line item. If my copier dies, I'm going to have to buy a new copier. But I think for the most part, we are a conservative and frugal lot. I want to talk to you a little bit about the need for the 3 judges in the 3rd, 6th, and 7th judicial districts. This isn't new. This need has existed for 10 years. When the first judicial district sought a fourth judge, they knew about the rest of us, and we talked amongst each other that they had the most need. But at the time, they knew that the third, sixth, and seventh was in need as well. Part of the reason that we haven't come before you before now is that times were tough, and we understood that. But our jobs haven't gotten any easier, and in fact, they've gotten harder. That's particularly true for the judges in the 7th and 6th Judicial District generally, and for Lincoln and Uintah County in my district. Our numbers have gone down a little bit in Sweetwater County, but in Lincoln and Uintah, they are up. And the problem in that area is that when you get up to that workload of somewhere between 1.3 and 1.4, that's a difficult workload. It's difficult for the judge, but it's difficult to achieve our constitutional duty to provide access to justice for the people that live with us. We can't schedule cases when it's that busy. And, you know, people say, well, why don't you get help from the other judges? And that works a little bit. But the problem is the facilities. If I go and help Judge Blumel and try a case for him, I'm in his courtroom. I'm preventing him from being able to do things in his courtroom. So it helps a little bit, and he can find other places to do little small things, but they need another judge. In the bill that was passed by the Joint Judiciary Committee, 2 of the districts, the 3rd and the 7th, are ready to go. They have a courtroom that can facilitate another judge. They have everything that they need. They have judicial office space, they have courtroom space, and they have counties that are supportive and that are willing to step up and support the physical plant. The 6th Judicial District needs to build another facility. And while they have the support of their commissioners, it's not done yet. So that will take a little bit of time and it won't be immediate, but the other 2 courts are ready to go. And so there's been some discussion this morning about our needs. If you have any questions, Judge Blumel and Judge Wilking are here, who are 2 of the most, or 2 of the judges that need another judge the most, and you can talk to them specifically. But I would tell you that things have changed over these 10 years. We talked a little bit this morning. You heard a little bit this morning about the kinds of cases that have changed, the pro se filers, some changes in the law. You know, we have the Johns cases now that we hear because of the stand your ground law that was passed. And so we have those occasionally. We have the factual innocence petitions that are filed by people that we have to deal with, seizure cases, you know, the financial, the monies that are taken in drug transactions or property. We have sex offender registration hearings that we haven't always had. And then we spoke about the juvenile cases that now require some things, and juvenile cases are incredibly time sensitive. And so when a juvenile case happens, it's drop everything and have a hearing. And that's not a bad thing. That's an important thing. The juvenile cases that we do in the district court are some of the most important things that we do. But they take time. And we have to keep space on our calendar because they're frequent. They come to us not on any schedule, but we know they'll come. Children in Wyoming suffer at the hands of all different kinds of things, and we have to be there and be ready to address those issues. The other thing that's happening, and I think it's been interesting, and I'm sure all of you see this, there's an anger, not in the country and in the state, that's filtering into our courts. The feelings, the polarized feelings between people, affect families. I have petitions in family court dealing with how each side is treating their children during these times of COVID, disagreeing with whether they're being homeschooled or whether they're wearing their masks or whether they're getting vaccines, because families don't agree. And so they fight and they come to court. And so that adds to the workload. And so things are busier now than they've ever been. And I think we've reached that time where it can't continue because the citizens in these jurisdictions aren't getting that access to justice that they deserve. Does anybody have any questions about the three judges? If not, I'll move on.
Representative Stiff.
Mr. Chairman, I guess I can't help myself. Judge Lavery, thank you so much for being here. On the third judicial district need for a judge, that seems pretty apparent to me, especially if you have a nuclear power plant going into Kemmerer. It's going to put a lot of pressure on Lincoln County, I would think. Natrona County, I'm less familiar with. The sixth judicial district, Campbell County area, there, I just wonder, it seems like the population there is not likely expected to grow as much. And so, I wonder about the need there. More broadly, Wyoming government generally, I think, struggles with diseconomies of scale. The legislature itself is a good example of that. We have 90 legislators spread over 580,000 people, essentially. So 1 out of every 6,000 people is a legislator in this state, whereas say in California, 39 million people, it's 1 out of 300,000 people are a legislator, right? So, if we had the California model, there would only be 1 member of the House and 1 member of the Senate, right? And we have 2 for the whole state. So it's a feature of our sparse population. We have some built-in diseconomies of scale. Leading up to my question, which is, has there been any look at how other states do this and how many judges per 10,000 residents they've got? Just by looking at the numbers roughly, it looks like, say, South Dakota, we've got about 1 judge per 10,000 residents, roughly, it seems. South Dakota, it's about 1 for every 14,000 residents. California, it's 1 for 20,000 residents. California is probably not a good comparator, right? Just because it's so very different. Anyway, how do we know when we need more judges? That's kind of the big picture question.
Well, so for our purposes, what we've relied upon is the workload study. And that kind of has driven our decision making. There's been discussion today about the accuracy of the workload study, but I think the general consensus is when that time comes, when we are fully implemented with full court and we get a new workload study, it will probably demonstrate that our workload is even higher because of the way things have changed, the amount of time it takes to get certain things done. Pro se filers are a great example. Self-represented litigants take up so much more of our time, especially in family law, but it's spreading. Pro se filers now file probates, they file guardianships, and those are complex areas. And for an individual to think they can do it by themselves, filling out a form, tough area. And it's also tough in the family law area if you have children and child support obligations. And so all of a sudden, you get a filing that's defective. And if it were a lawyer, you'd reject it because they know what to do. They'd fix it. But when it's a pro se filer, that requires a much more nuanced approach. You probably need to have a hearing. You probably need to give some explanation. And they may be able to fix it right there, but they may not be able to. And so, but we're relying on the workload study and the number of judges per 1,000. I mean, when you look at page DC1 of our of the budget book, we have some breakdowns of populations, and I think I don't know if I agree about the 6th Judicial District. They seem to be a resilient place. That would be what I would tell you in terms of what's happened to their economy up there. And I'm seeing that from a distance, but a lot of the things that we're seeing happening in southwestern Wyoming with the Natrium plant, if this works, then there's going to be more Natrium plants, and they're going to be up near Gillette and Douglas and in Sweetwater County. And if that happens, talking about Lincoln County. They're talking about a construction workforce of 2,000 to 3,000 people. Well, I grew up in Rock Springs, and so I was there for the boom in the 70s. And I practiced law in Evanston in the 80s, and I know what boom towns are like. And if you don't think it's going to make courts a whole lot busier, then you haven't seen a boom environment, because that's what happens. And it's across the board. I mean, there's good things and bad things that are happening in those courts, but we're going to be busy. And if you have that many workers in Lincoln County, it's going to affect Uinta County, and it's going to affect Sweetwater County, and it's probably going to affect Sublette County. That's just a lot of folks. And we've seen that before. But I think the same kinds of things will happen in Gillette. I saw today on a news item that the price of coal hit an all-time high. So, I think we'll chug along. We always have in Wyoming, and we've always found ways to keep it going. So I have no doubt about that. And I think these populations, when you look at them from the 2010 census and the 20 census, they've gone up. And so there's no reason to think that we're going to crater at any time.
Go ahead.
So this is a little bit off the budget thing, but I'm curious because during my time here, every time the district judges come up, they talk about the first is we're independent, we're each our own department, and we're not under the Supreme Court. And I understand the origins of that at statehood and so forth, and the concern for independence. But there are states with a model where it's integrated into the Supreme Court. And if in those states, are there issues with the Supreme Court impinging on the judicial integrity or independence of the district court judges? And are there advantages to having it all under one umbrella, if you know?
Mr. Chairman, Senator Tinsky, I really don't know where those things fall down. I know that the state of Utah has a unified court system. I think South Dakota does. The one thing I would suggest is when you start talking about that, say for example, we made everyone, instead of having a circuit court and a district court, you made everyone a district court judge, and they just did different things, under a unified system, and brought us all together. We'd be doing different kinds of work, but we'd all be the same. Instead of dividing up the work by geography, you divide it up by specialty. I don't know. When we're so rural that then you're going to have a lot of driving around places in the state. You won't have that in Casper, but or Cheyenne, and maybe not Gillette or Sweetwater County. But in a lot of places, you're just going to have judges on the road, and because we're so small in parts of our state, I think that was borne out when the county, well, actually justice of the peace, then county, then circuit. Getting judges into every county is a great thing. But when you get them in every county, some of them aren't as busy as others, unless they're sharing the workload and traveling. That's how you make that happen. And so I don't know how that works in South Dakota or in Utah or other places, but those would be some of the difficulties that I would see.
Follow up, Mr. Chairman.
Go ahead.
So the circuit courts are, I said integrated, you use a different term, but the Wyoming circuit courts are in a uniform court system. Are those judges specialized in driving all over the state as you worry about for the district courts?
They are not, but they have a judge in every county where we don't.
Thank you, Mr. Chairman. Thank you, Your Honor.
You're welcome.
Further questions? So I've got a couple just on this particular issue. I wonder if you would make available for us, because what you have are the judge on your workload studies, you've got it for the 3 judges. I'd like if you could get it for all the judges so we can see what those numbers are for every district judge. And if there were, and for example, I think it would be useful for us to know if there are locations where it's 2.5 or 2.6, where that judge should be traveling and we're not making him travel. And, for economies of scale, I think we just need to know those things. It's important for us to have a full picture of what's going on. And I presume that the Judiciary Committee is kind of taking a deeper dive into this, but I'd also like to know if the data is out there. I was just trying to find it, how much or equivalent district court judges in other states, what their workload is, if they're, how it compares to your workloads in terms of number of cases. It's been a while, but about 5 or 6 years ago, I sat down and worked through the workload study and how it's put together and how it's developed. And when I did that, there were some, at that time, I thought there were some pretty apparent flaws with it when I looked at it. But what I'd like to do is if you don't mind, and this is probably just for me, I'd like to see what the current study is and what it says and how they developed the information. Because once again, I think we as legislators have a fundamental obligation to understand what we're supporting and the background information on it. And so I would just like to do that homework. So if you could provide that to me and I can help, I can make sure that everyone else gets it. And then to respond a little bit to our good senator from Sheridan in Buffalo area, it's from, obviously from my background, it's entirely critical that district court judges remain independent. I mean, I was born with that in my blood, and I'll never lose that. And now that I've got a brother-in-law doing the same thing, I probably even feel stronger about it. But there are certain things that are important in that relationship. For me, the most important judges in the state are the district court judges. It's not the Supreme Court. You know, they're just kind of a court of appellate review, but the work gets done in the district court. That's where the hard decisions are made. And I do agree that it's critical that we have highly qualified folks that they're, you know, I know what Steve's workload is, and he works on weekends and he works late at night. So I want to make sure that we have sufficient judges to do the job that's in front of them. And I know that both the feds, the bar and the legislature have increased your workload. But a lot of your workload is stuff that is mundane as opposed to the hard stuff. And that's just a hard thing to figure out. And so if we have ways to work on that, or if you have suggestions on that, then we'd welcome interim studies or whatever we need to do to help facilitate your workload and how you get your work done. So I appreciate your help and your service, and we definitely want to do what we have to do to make things right.
Thank you, Mr. Chairman. And what I would say is that all of the workload assessments are published on the Supreme Court's website, but we're happy to get that to you. I think they go back to 2011.
Yeah, and I think what I want to go back and get the details of them and how they come up with the numbers on a more integrated basis. Okay, please proceed.
Then I would talk next about the district court budgets themselves. So we have a budget review committee that works with Claire Smith to review all the budgets that are prepared for the budget session by each district court judge. This year, all of the budgets are basically standard budgets with the exception of 4 budget exceptions. And with your permission, Mr. Chairman, I would address the exceptions unless you had questions about specific.
Committee, in the past, basically, we just had, for the courts, we've run through just the exceptions because their budgets are almost identical, other than a few anomalies. Fremont County has a little one, but I think that that would be appropriate as far as this chair is concerned, unless you have particular concerns. So, okay, go ahead, please.
Thank you, Mr. Chairman. Then the first page would be DC 13. And that is, that would be Judge Sharp asking for a copier.
No way.
Mr. Chairman, I was worried about that. If there are any questions about that, and that's also true of the second, which is DC 21, Judge Cricken needs a copier as well. And maybe if you told Judge Cricken yes and Judge Sharp no, he would get the point, but they both need copiers, and I think they were both, their previous copiers were purchased in 2014, so they're getting old.
Go ahead.
And then the next one is DC 63, and that would be Judge Conder and Lander, and he is returning money. There was a administrative assistant position that was shared between the county and the state, between the judicial branch and the county, and it's fallen apart. And
The county said no.
exactly. I was trying to be nice about that, but in any event, the Judge Conder has decided he doesn't need that position. So you see basically half of the salary and half of the other attendant, and he's simply saying he doesn't need that anymore.
Well, Judy Legursky is going to be sad.
Probably, yes. And then the last is DC 73, and Claire Smith spoke earlier today about that a bit, and that's the $20,000 request from Judge Day for travel expenses in conflict cases. And now we know, we didn't know it at the time that we were preparing all this, but all three of the candidates are from Teton County. I don't know that a person outside of Teton County could apply for that job and afford to live there. And so essentially, and I think all of the candidates litigate pretty extensively, and they're going to have conflicts. There's no question about it. You may notice in the narrative that Judge Day asked for some money last year. I think it was $10,000, but in any event, that was more for travel needs unrelated to that for other things, and trying to remember what it was.
Mr. Chairman, it was mostly because of his role in the executive committee of the conference, and so he had a lot of travel. He also had some cases that he had to have other judges come cover for him, and that's expensive.
Well, I think that Representative Schwartz would be happy to put a couple of district court judges up there and have them free room and board while they're, if they need to be there.
Mr. Chairman, that would be acceptable. We might need to discuss my rates.
So in any event, I do think that that's a reasonable amount. I think that all of these judges are going to, whoever it ends up being, all of them are going to have conflicts. And I know that in the past, I think all of us here have probably taken cases in Teton County, and it is expensive to go up there and try a case.
Please proceed.
Chairman.
Go ahead.
Thank you, Mr. Chairman. You indicated earlier in the day that this 20,000 would be one time. If these folks are all from Teton County, their history in Teton County will not pass in the next 2 years. So will that really become ongoing because they will have a potential for conflicts into the future beyond the 2 years of this biennium?
Thank you, Mr. Chairman. Representative Walters, you hope that the conflicts reduce over time. That's the hope, that the particular, but in some cases they'll continue. I actually moved from Evanston to Green River when I became judge, and so it was nice. I didn't have many conflicts. On the other hand, when Judge Robinson was appointed a while back, she practiced law there. She was a county attorney there, and she's just getting ready, just a little over 2 years. She still has conflicts at times, but that amount reduces. That's what happens. It doesn't stay the same. But off the bat, there's going to be, like, if one of the candidates is the county attorney, if she gets appointed, she's going to have a criminal caseload that she's going to have a problem with. And so somebody's going to have to help out with that.
And they tend to be a bit more litigious up in Teton County. Okay.
So that concludes the district court exceptions. I would say that we heard this morning the request made by the judicial branch and the district court judges support their requests as well, especially the across the branch. Technology is a great thing, but it costs some money but we are pleased with the technology that we have. I would tell you that the things that we're able to do in the courtroom now, our ability to handle proceedings through COVID, we wouldn't have been able to do it without the technology that we have. It's really been a good thing.
Okay, any further questions? Judge, we appreciate it very much. Thank you for presenting the
Thank you.
presentation. Don, what are we up to next?
Mr. Chairman, I believe Ms. Soto is here for the,
For the Commission of Judicial Conduct?
yes.
Okay, come on up.
Mr. Chairman, I
Welcome.
believe that, good morning. I believe that Chairman Elser should be joining us on Zoom to give a brief presentation. Oh, boy. Well, I believe Mr. Elser, Chairman Nicholas, Co-Chairman Perkins, I believe that Chairman Elser was going to speak to you about a little bit about what the commission does. And I don't believe we have any new members here that need to be educated. So essentially, I can just tell you short and simple, as our presentation always is, there are no exception requests in our budget. We operate pretty frugally. Typical expenses for this small office include personnel, travel for meetings and training, although we are doing a lot more virtually now, as everyone is. Administrative technology and office expenses and the cost of hiring disciplinary counsel when that's needed. Again, the commission has no exception requests for this biennium. You can see the detail of the proposed budget on page 8 and column 5 of our budget book. The request for the 23-24 biennium is $333,103. The only
So-
changes,
So Wendy, it says that the number of complaints have been remained relatively stable for the past few years. Is that accurate?
that is true, Chairman Nicholas, although this year we have seen a little uptick in our numbers so far this year.
How many?
I believe right now we've had 35.
How many of those tend to be superficial that you can kind of discard rather quickly?
Well, I think, Chairman Nicholas, if you look at our annual report, we do have a section for summarily dismissed on page 2. And it runs the gamut. If you can see in 2016, 17 of those cases were summarily dismissed. That's 2016, I'm sorry. 2017, there were 7. In 2019, there were 28. So it's not as many of our numbers are, not a predictable number.
Okay, thank you. Please.
First, I'm not sure we got that report, but that's not critical. My question is, in your budget narrative, you reference increasing complexity, or I believe the word was more involved. And I'm just curious what that means and if you know why.
Mr. Chairman, Representative Schwartz, I did provide the annual report, so I don't know why you don't have it. My apologies for that, and I'll make sure that you get that document.
There's a good chance it's my fault.
I really can't, I don't know the answer to the question. I think in some respects that the number has increased somewhat because the commission is more well-known than it has been in the past. It's before my time with the commission, it was not in a public setting, it was in a private office. So, and we have continued to provide some education. We've attended, for instance, we have spoken to the district court conference, the circuit court conference. We have spoken to Legal Assistance of Wyoming conferences. So I think there's an increasing knowledge in the public and in the legal profession about the commission. So that may have something to do with it. You're welcome.
Please, go ahead.
I think you're. Representative Schwartz, thank you. Mr. Chairman, so just following up on that a little bit, I mean, we've talked a little bit about I think like I said, they're more involved. And so the nature of those seems to be, as it seems to be evolving or changing a little bit. That's what I took from your comment. And so I'd just like to follow up on that thought. And is there any trend that you see with the complaints coming from, litigants or individuals who've been in the courtroom and didn't think they were treated fairly versus attorneys who are making complaints that judges have not acted appropriately? Are you seeing any change there? Is there any, I just wondered about where you see trends or if you see anything that looks like it might be coming.
Chairman Nicholas, Co-Chairman Perkins. The vast majority of complaints that come to the commission are litigants who are unhappy with something that happened to them in a courtroom. And many of those are those cases that are summarily dismissed. I don't see any particular trends with regard to changes about complainants. So I think the answer is no.
Okay, thank you.
You're welcome.
Any further questions?
The chairman making?
Yeah.
You
I
did pretty
don't-
well for flying solo.
Yeah.
Well, I do have commissioners here with us. As many of you may know, the commission is made up of 12 people, 3 judges, 2 district court judges who both are with us. Judge Wilking and Judge Lavery are serving on the commission. And then, we have a circuit court judge, we have 3 attorneys, and then we have 6 citizen members who are appointed by the governor, and Karen Meister Emmerich has joined us too. So I do have a little moral support.
Well, you did fine. We don't need to hear from them.
Well, thank you.
Thank
If
you
there's
very
nothing
much.
else, then that's my presentation.
Okay, thank you very much.
Thank you.
Don?
Mr. Chairman, you actually don't have anything scheduled until 1 p.m. Those individuals are either YouTubing in or Zooming in, excuse me, or are traveling.
Okay, so we want to do any bill discussions?
If you want to do some bill discussions, we can do that. I do have a couple of questions for Kevin. That I didn't get asked today that I still want to follow up on, and we probably got a few minutes. Whether you're welcome, it's a public hearing, you're welcome to stay and listen, or you can be out of your way. And, so I just want to come.
Hey, Lisa.
You guys missed the The fan?
Sorry,
Mr.
but
Chairman,
Bob, can you get close to your mic? I'm really
Actually,
struggling to hear your
it'd be
voice.
December 23 or January 1 of 24. Yeah.
And has Judiciary done anything like that? Do we know?
Mr. Chairman, I don't believe so. It would require a separate bill aside from the budget bill. And we could, right now it says March 2023. If you'd like December 2023.
Yeah, I
I
think
think
we would.
March or January 1 of 2024, I think is what we'd want.
Is it, right now, do retired judges have the ability to serve in Chancery?
They do on the panel, yes. And so is there, when we do on the panel, is there, when we changed that and moved the date a few years ago, we pushed the Chancery Court appointment back, judge appointment back a little bit. Did we also roll back, did we sunset, or is there an automatic sunset on the use of the district court panel or our judges with that? That's at one point, I know there was that ability ran out, but did we remove that completely, or did we reinstate, we just push that deadline out too?
Mr. Chairman, members of the committee, I think it is contingent upon that March 2023 date. For example, the statute says prior to the appointment of a Chancery Court judge under subsection B, which is the March 2023. This section, or in the event of a Chancery Court judge being appointed, becomes unwilling or unable to perform their duties, then you have that panel approach.
Why don't we do, Mr. Chairman, we should try to modify that for right now and just, even just like with conflicts and things like that, I think that's already covered if there's a conflict. But the other side of it is, why don't we just push that? We'll at least need to push that deadline. That'll happen. That just happens automatically from the date of the appointment.
Mr. Chairman, that's correct.
Do we want to put in language to either allow a special master or a magistrate's to?
I don't know. I think that's already, I don't know if that's in the rules or not. But it just seemed to me that it wouldn't be bad to allow magistrate or commissioner for them to be appointed as necessary.
Yeah, just check and see if it's in there.
Mr. Chairman, it does not appear to be currently. Right now, the qualifications for this temporarily assigned duties includes retired Supreme Court justice, retired district court judge, or a member of a panel of up to 5 active district court judges. So that would be maybe a fourth alternative.
Bob, not to chase any rabbits. Tell me what special master or magistrate, under what circumstances would you want that?
Well, the circumstance you want that is one, you don't have the judge yet.
Okay.
So you don't have the judge. So now you've got a panel of up to 5 circuit court judges, which right now there's 3, but one of them is going to Supreme Court. So John Finn was one of the 3, but he's going to Supreme Court. So you'll be the other 2, but maybe there's somebody else. But their caseloads are full too. So the object of the magistrate is to deal with some of the initial issues that come up. They can issue the standing court rule. They have motions for this or motion for that, motion to dismiss.
Okay.
To deal with discovery issues. And so, and the federal,
that would be an attorney appointed to that.
yeah, generally so generally in the federal court system, you've had, now you have full-time magistrates, but there were, I remember John Brooks, before he was a judge, he was a part-time magistrate. When they needed him, they called him, he came over and he would sit down and he would do that as a magistrate. And so they just do what they're not sitting in office waiting around there. It's a part-time thing, it's practicing attorneys. Okay. And they just deal with some of those things. And so they, you can figure out the contract an hourly basis, whatever they can pay it. But it's just again, why we're going up because obviously we don't want people standing around with the other for cases to show up if they're not.
Okay, what else?
Is that a bill for us?
We'll do it. It's easier for us.
Judiciary can't do it because they're done. We're the only joint committee that still meets our legislature.
Okay, did you have another bill?
It did, but I can't remember what it was.
We want to do anything for veterans tax?
Yeah, what do you want to do anything on veterans taxes?
I think that Senator Steinmetz wants to have another discussion with
We'd
the guys
love to
hanging
load 'em
around
up. We'll load them up.
VFW.
Come and talk to us during session.
Walters and I are still in shock from the beating we took when we went before that committee.
So I'll tell you the one thing, I mean, the one thing that would
Yes.
interest me is what do you think about establishing a cap? A cap and and what I'm talking about, there are two caps I was thinking about. One of them is a cap on just the total amount of tax. If I've got a $6 million home in Campbell County or Jackson, and I'm a veteran, because I don't know that there's a cap on it. Or is there? The $600 cap?
Mr. Chairman, there is an annual cap of $3,000. There
Okay.
previously was either a lifetime maximum as well.
There was a 10,000 lifetime maximum or something.
I don't recall the amount, but there was some lifetime maximum.
Seems like he does.
But you can be driving a $150,000 BMW and you get your license plate free, essentially. So the idea that those who can afford it, to me, I think we ought to have a cap, and there might have to have some type of an income-based benefit.
Oh, Mr. Chairman, I'm telling you, I think all of those are appropriate and fair.
Don't you have to turn it off?
I think all of those are appropriate and fair. And we do need you. But I think we've got some work ahead of us to get it through committee. That the service groups and everybody really come out in force. And so, if we're going to do that, we need to start getting a plan ready for that as well.
Well, I don't think, I see it a little bit differently. Last time we were talking about actually reducing the benefit across the board. You're not talking about then, you're saying, all right, we'll let you have up to this much. They're just saying there's limits on it, which aren't going to affect most common folk, most folks that I know, they're in that category, are not going to be affected by it.
Mr. Chairman, the testimony that Lloyd and I heard when we were trying to present this is seen as a benefit, and I would argue that it's really a gift from the state.
Yeah.
And that's something that needs to be better clarified. But any change to it whatsoever was not accepted by these groups. They didn't want a reduction. They didn't want a cap. They didn't want to work with the legislature to do anything to make these programs more sustainable.
So
They see it as an
think part of that-
expected benefit, and any change is going to be met with significant resistance.
And I might add, there's the residency issue as well. Because I know I've talked to at least, you referenced Teton County. I've talked to at least 2 veterans who part of the reason they bought a house in Teton County was because of the veterans tax exemption. And they did not buy, how should we say, below the median value home.
Mr. Chairman, one of the things I've been thinking about as this subject came up is, it was one thing when we were facing deficits and we were making all the reductions and we were asking people to join Team Wyoming. But to come into a situation where we're flush with money, we're giving state employees raises possibly, I think it's bad optics to go after the veterans, what they see as a benefit. Just my opinion.
Mr. Chairman, my recollection is, I remember there was blood on the floor, all the cuts, and the veterans came in and said, I mean, we talked to them for a while, and then they said, well, if everybody else is stepping up to the plate, we will too. But this year, a lot of stuff that was taken away is being put back, so. But, you know, a cap makes all the sense in the world. Or an income means test.
Well, I'm willing to put my feet in the fire because I just think it's the right thing. But we have to make sure it goes to just this committee and it doesn't do anyone else.
Mr. Chairman, there's a seniors property tax exemption that's means tested. How do the seniors prove eligibility for that? They have to take their tax return down to the county office or?
I think it's based upon your word.
Oh. Okay.
Means test.
Mr. Chairman? Yeah, it is. It's just a form you fill out.
Yeah.
You declare, but there's no, I mean, they can, I guess, audit you, but right now it's just a form that you go in and fill out.
This may not be the year for it.
Could be. And it's a budget session, so it makes it hard.
Well, something I'm sure.
Anything else that we were looking at? I thought there was something else.
Well, there's some stuff with, no, I think the rest of the stuff was Catherine, so that's gonna work on. So I did have a couple more questions for Kevin, just general. Unless there's more bill draft requests. Kevin, just a couple of the questions. You know, the governor said in his remarks that he wanted, you know, that I think the replacement funds, the Arpa replacement funds for the most part, he just wanted to deposit in the LSRA for right now. It's kind of what, if I remember his opening remarks correctly, do I remember that right?
Mr. Chairman, are we talking about the calculated amount of revenue assistance? 502 million?
Yes.
I don't know that he had taken a position of depositing that into the LSRA is currently in a general fund. The amount that we've actually brought back is residing in the general fund. I think the comments that he would have would be that the revenue assistance fund, the $502 million would be perhaps a first option for matching the infrastructure bill if we see it. And then the lizard would be the second option for the infrastructure.
We're just talking about, I think what we're getting at is I think the sweep at the end. So, you know, as we go through and we appropriate at the end, when we come back to the reconciliation balanced budget, then generally the excess of the general fund gets swept somewhere. And so I took it from his remarks. Right now, that'll change as it goes along. So every time we allocate or there's appropriation goes through that's not line item by the governor, at the end of the day, there's going to be a surplus, and that surplus is going to go somewhere. And it's his preference essentially LSRA.
Mr. Chairman, naturally, the strike force will do exactly what you just said. And then whatever that residual amount, I think the obvious place would be is the ledger, because there's investment opportunities that are greater than just simply the pool from the general.
Okay. And then is there, so, you know, so last year, the governor vetoed a lot of the Section 310 language, and when the governor did that line item veto, then several agencies, and we've heard that, and we'll continue to hear some of that, they're able to use the vacancy salaries, the vacancy savings to redistribute within the agencies in a few circumstances. Provided priorities, we've been talking about that. And so, I mean, we talked a little bit about that going forward, but overall, as we look at the HR practices going forward, do you see any limits or restrictions that the governor's office, your office feels is important that we just put in, or language that you might want to see in the budget to help with that, or handle it through HR rules? What are y'all thinking about that?
Yes, Mr. Chairman, I have had a couple of conversations with the governor in this specificity. And those conversations is centered on the budget aspect of our conversation and giving and keeping the provision in there that the governor can make decisions on salary increases with his permission or his designee, still be able to accomplish that. You know, a good example is that is nurses. You know, in COVID, I can't really get a better example of a situation where the governor would have to act, and that's where that provision would be him or his designee. That's on the HR side of the fence. So that keeps the HR mobile and flexible. But on the budget side of the fence, perhaps a conversation suggests something along the lines of what we normally would do anyway, and that would be like, we balanced the budget and we showed where the agency didn't cross the biennium with more money. When they did cross the biennium with more money, we asked to do an exception request. That's the budget conversation, but that's not an HR conversation. So we want to have HR flexibility, but we also want to make sure that we have budget conversation.
Right, and I think, you know, our concern is, I think just trying to help with that. I mean, what none of us want to see, and this is a little, it's a little bit different, but none of us want to see the real estate commission issue show up again. And so just looking about so that, you know, it's not necessarily, you know, trying to figure out the right restriction mechanism for that. Not for the governor or the governor's office necessarily, but more for directors individually acting on their own without having some kind of thoughtful process about when that's appropriate. Just trying to find the right checks and balances in there.
I think that's what we're all striving for, and not to get too far more advanced, certainly not getting in front of the governor on any topic. We have had those discussions, and I've got a 3-paragraph recommendation that they're reviewing now. And hopefully that will come through the process and we'll be able to share that.
Are you looking for that to be to have us include that in some kind of budget?
That would be, if this becomes the will of the governor, then yes, but not until such time as we.
All right, and this is, I'm just asking it now, so as we go through this process, you know, obviously we're not going to work on a lot of that stuff till we mark up the budget, but just wanted to bring that up so that we're thinking about that, and we can get the right thing in there that we, you know, then the governor doesn't have to line item veto it, or we still have the controls we all want.
I think that's our wish, would be to collaborate on that, and we're not at ground zero on it because we have been having the conversations. And then as that conversation mature, and ultimately that might be a governor's letter.
Okay, I appreciate that. And that's what bringing it up now. So we have time to ferment and foment a little bit so we get it right at the end.
So I think Don says that the county attorneys can come in and present before lunch.
Okay,
Yes,
great.
Mr. Chairman, I believe it's about a half hour or so before lunch. He has been promoted from the 1 p.m. slot, and I believe he will be appearing via Zoom.
Right now?
Any second now? We can congratulate him on his promotion.
Will Representative Simpson be joining?
It's the prosecuting attorneys. That's what we're hearing. The prosecuting is not the district attorney, but the prosecuting attorneys.
Mr. Chairman,
Yeah, so what?
Mr. Chairman. Mr. Chairman, I would like to ask the gentleman on stream to unmute himself if he would like to speak.
I believe am I unmuted?
Yes, we see you, John.
Okay, thank you. My name is Joseph Barron. I'm the Crook County Attorney from Sundance, Wyoming. I'm here on behalf of the Wyoming County and Prosecuting Attorneys Association and the county attorneys across the state. Thank you, first of all, for being allowed to appear by Zoom to address this. This budget, for those of you that may not know, is a reimbursement budget. It pays for a portion of the elected county attorneys' salaries and a portion up to $30,000, one half up to $30,000 of any deputy county attorney, and one half of the elected county attorney's salary. The county commissioners pay for everything else in the 21 counties that receive these funds. Anecdotally, it covers about 35% of the expense of my office. The district attorney's office by statutes are paid for by 100% by the state of Wyoming in both Natrona County and Laramie County, which coincidentally are one county districts. And that's the way it's been since this system has been in place in approximately 1980. The budget request that I submitted some documents to the committee and I presented these same very similar documents with our meetings with the governor's office and staff in the past. And we had requested the exception request to restore this budget back to the 2021-22 fiscal year. And so you're aware that there's any non-reimbursed funds, they revert back to the state at that time, at the end of the budget cycle. And the other thing is that right now, I learned a new word here at the last meeting that I had with the staffing, is that a clawback. Currently, because of the budget cuts that have been made over the last fiscal biennium budget, we are probably going to be short in the fiscal year 2022 budget year up to upwards of $500,000. It probably is going to be less than that, maybe a couple $100,000 less, just because we're starting to experience unfilled positions across the state in various offices around the state. I think right now we have 6 to 8 unfilled positions. I know over in Sublette County, when they raised their salary to $94,500, and they started to, Mr. Crossan said he had a couple people apply for the jobs that had been open, I believe, at $75 for quite some time before that. But that's the request that the County Attorneys Association, myself, and the others have in this particular budget. I set out in those documents, the history of, for those that aren't aware of how this came about and where it's been and where it's, at least in my estimation, going, given the wage issues. And I understand the state is having similar issues as well. And I know in the comments that I've received around the state right now, people are leaving prosecutor's office for the public defender's office because the state has brought some of those wages up. And so that's starting to occur. And of course, prosecutors apply for the judiciary because frankly, because it pays more. And there, and so what it suggests to the committee is that it shouldn't be one against the other in the prosecutors, the public defenders, or the judiciary. It should be all of the above in these matters. And I would just stand for any questions that you might have about any of the issues that questions that you might have about this particular budget. I had one other thing I just asked the committee, let the committee know, is that when this budget came about and these cuts came about, I had asked earlier this year, about the Arpa funds and other funds at the previous meetings on this. And my recollection of that is that that was going to be to the legislature to decide on that. And I think if the funds are available, they ought to be used to backfill the budgets that were cut because of the cutbacks at the state due to the pandemic and the loss in tax revenue to the state of Wyoming.
Mr. Chairman.
Go ahead.
Are you done, Joe? I don't want to interrupt you.
Yes, I'm done. Thank you.
Mr. Chairman, and perhaps it's a question for Mr. Hibbert. I understood the governor's pay plan was to extend to all branches of government. I've got the performance pay plan here on page 141. It shows moving district attorneys to market, District Attorney Laramie County, and then 157 District Attorney Natrona County, but there's nothing for 160 prosecuting attorneys. And I wonder if that's, if they were intentionally omitted, or they're not part of the pay plan, or if they're part of the pay plan, just not in this book. Thank you, Mr. Chairman.
Mr. Chairman, the delineation of that is that the district attorneys are on the budget, and we have budget books and they go through the legislature. And that's what their positions in the whole functionality. So that's why they're included in that book. The county prosecuting attorneys are not, and that's the delineation. Now we have the funding that we assist them, but they're not actually positions.
Mr. Chairman.
Go ahead.
So I don't understand the intricacies of the county attorney funding, but would it be possible to somehow roll getting them to market on the same table as the district attorneys, whether that's in the budget? I would hope it wouldn't require separate legislation, but perhaps, well, I'd say somebody who knows more than me, but that's a very large class of people. But could somebody tell me how we might affect that?
Every county has to do
Yeah.
that.
Pardon?
Mr. Chairman?
Go ahead.
Every county would have to do what I think that the current statute provides that we assist with, as we're talking about, as we look at this appropriation, we assist in providing additional expenditures to the counties. And I think, if I remember right, I think it's in the narrative, which seems to be right, that assistant deputies attorney are paid 50% of their actual salaries up to a cap of $30,000. So it's up to the counties to pay their attorneys whatever they are, but the state's contribution towards the assistant DAs is limited right now at $30,000 a year. So if we were to extend additional money to the counties to do that, you would have to actually change the statute to raise the cap over and above the $30,000 per year per deputy county attorney assistant is how I think it would work.
So then, Mr. Chairman, I guess I'd go back to Mr. Barron. I'm not sure what the ask is. I see all the information about how they're underpaid. I'm just not sure what the mechanism is to change that. Mr. Barron, you're asking for a bill to raise the 30,000 and to increase the state's contribution. And is that right? Is that how it'd have to work?
Well, I think, Mr. Chairman, if I may, Joe, are you still there?
Yes, I'm.
Okay, so Joe, as I understood your ask, there was a pretty good there was a pretty good cut that was taken. We were cutting budgets last year. And as I understand your ask, what you're asking for is $633,634 as a budget exception. Add back the budget to restore your budget for the 2021 level. And then, but then the other thing I see in the exception request explanations, you're requesting basically a $500,000 clawback from the 2023-2024 budget to adequately fund the rest of this year. And so as I understand that, I think you're asking for 633,000 and change in your exception request, but you're asking for essentially this 500,000 to be effective immediately to help you finish out the remainder of this fiscal year we're in right now. Is that how I understand that right?
Mr. Chairman, Senator Perkins, yes. And probably the way this budget works is this. And simple answer is yes, that's what we're asking for. The way this budget works is that it's set up on a reimbursement basis to the county. The county commissioners set the salaries, they do all that. And then at the end of the fiscal year, the Attorney General's office, Steve Weiner, send out some forms to the clerk. They fill in how much the county have spent each month on county attorneys, and then they gather that information. Then they send a check to each particular county. And the counties have buy-in in this because the commissioners do, because they have that. So in response to Senator Kinski's inquiry is that these funds assist the county commissioners in keeping these jobs open and on board and open. Although that may be a request somewhere down the road is to change that formula, that request is not something that I'm bringing. We just, at this point, just want the money to keep us at the status quo. And so the other thing is with the clawback provision in this, I would certainly anticipate if there is a need that we would be coming in the middle of the biennium for a supplemental request. The way this budget has always operated is that even though the funds within there revert to the state, if they're not paid, in the beginning, we had a lot of extra funds in there. We budgeted for every contingency. Well, as things became tighter and tighter at the state level, then that number became closer and closer to what we anticipated. I think this last time it was, within thousands of dollars, and rather than tens of thousands of dollars on that. And we've been told to do that through Judiciary, just to do it in that manner because of the basis of the reimbursement and the fact that the legislature does not have control over the number of folks there are other than electeds. I mean, you control a number of counties, therefore there's going to be 21 elected county attorneys, but the deputies are there, and the legislature has trusted the county commissioners since they've had a huge stake in this to make those particular judgments. Now, back in 2013, I believe Senator Perkins created this. There is a clause in there that if there's insufficient funds within this particular appropriation, that the lack of funding would be prorated between the counties that make the request on that. And so at this point, if there's not some kind of a clawback provision allowed, then that particular language in the statute will come into effect.
Chairman. So I just want to try and make sure I'm understanding this, and I apologize for not knowing more than I do. So if the idea is, when we made these cuts, the county then had to pick up what we weren't paying for, and so the county can't pay more to their attorneys. So the idea is, if we appropriate $1.133 million, that takes the burden off the counties, and the counties will turn around and give raises to all the attorneys. Is that the underlying assumption? No? How does this alleviate the underpayment short? Everything in here is about lawyers being underpaid. I'm trying to figure out what the mechanism is that the 1.1 million is going to alleviate that. Help me understand.
Chairman? Go ahead. Mr. Chairman, all the result of the budget cut was, we cut the budget was, it just meant that state aid to counties to offset costs of their prosecuting attorneys, of their county attorney staffs, was reduced. And so that just meant the counties then were choice with either laying off people, adjusting budgets, or finding money elsewhere to keep the county attorney whole. Is that right, Joe?
Mr. Chairman, Senator Perkins, correct. The emphasis on, we're having problems now keeping people. If this money is not restored, I believe that the actions is that there's going to be further positions that will be cut and go unfilled.
So for example, in your office, Joe, how many attorneys do you got? How many attorneys do you have?
Two.
And
me and my deputy.
Me and your deputy. And so you get so I don't think the $30,000 applies to you, but there's a $30,000 benefit that comes to help offset the salary of your deputy. Is that right?
Yes.
And so if this is restored, then the amount that goes to reimburse your deputy is reduced accordingly. And so now the county either has to, if they're going to keep your deputy, they have to make up the difference, or they have to cut the salary, or they say, Joe, we can only afford a half or 3/4 of a deputy for you. Would that be the result at your county?
Mr. Chairman, Senator Perkins, that possibility exists, and that's what I try to reflect in one of the comments I make, is that and this is already happening, is that some counties are going back to part-time county attorneys. I know Weston County does it extensively now, and I know Converse and some of the other counties are doing this.
Okay, Joe.
No,
it's not restored. So Joe, the other thing I have is I'm a little confused on the exception request that's in the budget book that we're looking at is for $633,000, $633,000 and a little bit more, a little bit and change. And so I get that. That restores, it basically puts the budget for the biennium, for the biennium of 2021, 2022 biennium back. That makes it for the 2023, 2024 biennium, it puts it back to where you were. So you have the same budget going into the coming biennium as you do in this, we had at the beginning of this biennium. Is that right?
Yes.
And so then I think the other part then is the request that I'm not seeing in the budget book is the clawback for $499, $4,499, $500,000. I can't speak today. So this $500,000 request, that's not effective immediately out of the 633. You're asking for that is also an additional request. So it's in the budget book, but that's what's in the narrative that you gave us. Is that what it is?
Mr. Chairman, Senator Perkins, when I submitted that, frankly, I didn't understand that that's what I needed to do. I probably should have asked for, 1.1 million. One to do the backfill and two to do the exception request and two to do the clawback or to pay for fiscal year 2022. That's what I should have probably done. I did not do that. I didn't quite understand that. That's my fault.
So Joe, I have a question. This was equivalent to what, a 10% reduction? The 633,000?
Yes.
And so if you have one deputy and you receive $30,000 a year for that deputy or reimbursement, what did it go down to? Did you go down to 25,000?
Mr. Chairman, it hasn't gone down because the bill hasn't been, it won't be submitted until June of 22. So the way that it works is that salaries are not reduced in the first year of the biennium.
So
And
what will the reduction be though when it goes into effect? How much?
Well, let's see. I'd have to check that. I'd have to do the numbers on that with the 500 and send it out to everything. But if it's 10%, it could be $3,000.
Okay.
And I may be wrong about that because it's different counties have different assistants and it changes, the numbers change throughout the year. So like I said, we have 8 unfilled positions or 6 to 8 unfilled positions for 6 months. There's going to be less of a need for that.
So, one of the reasons that one of our questions are, because every county got a certain amount of ARPA dollars that showed up on their doorstep. And so one of the arguments is going to be that your county will have a bit additional dollars to come up with $3,000 that you're not receiving for the county attorney's office. Have you had that discussion with your commissioners?
Mr. Chairman, I have. And I do not know exactly what the submittal is. We have not submitted anything yet for our last year for our revenue versus expense. My understanding of it is, since the clerk is the one that's dealing with that, is that if our revenue for the prior year exceeds the expenses for the prior year or the previous year's tax revenue, however that works, that we're not entitled to use those ARA funds for backfill on that. But it is a possibility that those locally received funds can be used to backfill. I would think even funds that we don't receive from the state.
Okay, thank you. Other questions for Joe? Further questions? Anything else, Joe?
No, just ask you, just to let you guys know, the county attorneys have sought a sponsor to go to the legislature to have the cap increased on the electeds and give that authority to the county commissioners to set those salaries at a higher cap level, the same as a district court judge. So in that regard, then maybe we'll keep some county attorneys and district attorneys in that status rather than having them jump ship to the judiciary.
So has the Judicial Committee sponsored a bill of that nature for you?
No, committee has not.
Did you ask them to?
I think I did not do that. They asked Mr. Greer. It wasn't on. We asked for that to be on an interim topic, and it was not placed as an interim topic, but they heard it at the last Judiciary Committee meeting. And my understanding is that we have Mr. Greer as a sponsor for that particular bill, and it's in the works.
And so basically what you're asking for is just authority to pay district attorneys more. Is that correct?
County attorneys, yes, county attorneys more, and obviously district attorneys that, because they're prosecutors too.
Well, I think we might be happy to submit a bill of that nature. I'd like to be able to pay the district attorneys more too, but it's got to come out of the county coffers. So just have them authority. If they want to pay them more, kind of like Gillette. Gillette pays their county attorney 120, 130,000.
No, Mr. Chairman, they do not.
Their deputies, yeah, just their deputies.
Just say, yeah, and there's a number of counties that have deputies that make more than the elected. Teton County, Converse County, I believe maybe Sweetwater County. There's some that are already out there that are in that boat.
Okay. So did you say Greer is going to bring that bill?
Yes.
Okay. All right. Well, thank you.
Okay, thank you. Thank you for allowing me to appear this way and step in early and do that. Looked like you guys you're moving right along.
Yeah. I think they could come up with $3,000. Okay, we're done. Thanks, Joe. We're going to adjourn for lunch or recess for lunch.